Sir, you're charged with especially aggravated kidnapping. You're also charged with aggravated assault, and you're charged with theft of a firearm worth less than $2,500.
You're talking about stuff that is not relevant.
Hello and welcome to the Court of Public Opinion. I am the recovery addict, and boy, do I have a case for you today.
Why is the dog chewing on this guy?
I think they have got the wrong guy there.
Got the wrong guy, and the dog was biting him.
He roughened him up quite a bit. There's a lawsuit.
All right. Try to get everything squared away. Welcome back from lunch. I know it seems like we were just here, right? It seems like we were just here. Welcome back to the Court of Public Opinion. I am the recovery addict. Thank you for joining me for part 2 of today's trial. It's turned out to be a spicy one. Wisconsin versus Zachariah Anderson is it's getting hot in there. It's getting hot. The judge is getting fired up. The attorneys are already fired up. It's going to be good. It's going to be fantastic. Welcome back, everyone who's here. Let's see. I think the person who needs the most welcome is going to be Adam Nusky. Adam Nusky, first in chat after the break, says hello. He says most of hello. It's more like a helicopter type thing, but being first in chat has its privileges or its punishments, depending on how you look on it. And Adam, you are the grand winner. The winner of all things internet related. So we will gift you the internet, or re-gift as the case might be. So thank you very much, Adam, for breaking the ice in chat, letting everybody know the water's fine. Come on in. Good to have you, MCAT, Portland Trail Blazers, Michelle Stark, MCAT, all you guys who made it back here early. We are going to get we're going to get back to the trial here in just a minute. Taper Dave, the judgment's repeated statement. I'm not going to tell you what to do. I've got, let me switch this over here. I think this is on replay here. So for those of you who don't know, I do have a little device that lets me mess around with the audio and play through, so I can forward.
Which has been pretty consistent throughout the trial.
I can play back and forth with what I want. I can jog it however I need. So I'm going to pull the replay off there in just a minute, but I've got that set up. So there were a couple good sound bites in there. One of them was about the "Don't interrupt me," and one was the "I'm not going to tell you what to do." I'll probably pull those off tonight because that'll take some time. Meanwhile, we've got the actual court, which is right here, live right there. That we're waiting for the judge to get back. He gave him a very, very short lunch. Very short lunch. I'm back for some lawyer fights. You're at the right place, Golden Mom. This is the trial for it. Katrina says, lurk mode activated. Some people have to get some work done. I'm sorry for you, Christina. I feel bad. Cupcake says, I just subbed to you this morning. I absolutely love your voice. It's very soothing. Thank you, Cupcake. This gets me excited. I get a little bit more animated when there's a case like this. I love the legal arguments. The actual facts of the case back and forth, they're intriguing, but they're not what draw me in on this trial. It's the legal arguments. See, MCAT says, that's funny. My screen showed my comment first, but Judge R.A. rules. Did I miss Judge? I do show Adam Nusky first on mine, MCAT. I do apologize. It was probably within milliseconds. So I've got to go with how Google Chrome called it for me. But you'll win eventually, MCAT. I think you have once already, though. Right? Michael DeVito says, I watch Scott no matter where I am. At the moment, I'm in line at the pharmacy. To all those people in front of Michael DeVito, he has, I don't want to go into the details. There's an emergency, and if you could please let him up to the front of the line and get what he needs at the pharmacy, we'd all appreciate it. So thank you. Michael, I hope that helped. Let's see. Don't interrupt me is another great one. We've got a couple good sound bites. I think we're going to have better stuff this afternoon, because the pressure is rising, right? We're in a pressure cooker, and as we're building, you've got to realize, I think somebody in chat mentioned this a little bit earlier, that we still have Sadie coming up. And Sadie's the one that where during the opening statements defense was making, the state objected because of the Denny implications, basically where they said Sadie could have done it. She's going to be cross-examined by the defense at some point during this trial. It might be today. It would be crazy if it was. But can you imagine if she brings up these same arguments to Sadie? Because I don't think the judge will go as lightly as he did this time if it happens again, which I think it is, because it's a key part of the defense strategy is to attack the credibility of the investigation. And do that by showing that other people could have been suspects when they're not. And the judges ruled on it. It would be a Denny issue that they said no is not coming in, and she keeps going there. So we'll see if she's able to do this through a back door, which we saw the state do yesterday with something that they had been ruled against. But we'll see. They're good lawyers. They know there are more than one ways to get to a certain objective. It is going to be good. It's going to be fantastic. Let's see. Stephanie Willis says, I have to leave for a meeting at 1. Can you possibly go over the first mistrial? Yes, Stephanie Willis. The first mistrial happened because the state, the white-haired attorney, Gravely, I think his name is, found out that one of the witnesses, and it was the woman who was supposed to meet with the victim, like they had met online or something. They were supposed to meet with the victim, and she went to the wrong house. That woman had changed her story. And so the district attorney, met with her and found out that information and did not provide that to the defense. That's like a discovery violation. It's really bad. And so they were completely, broadsided by a change of testimony that wasn't what she had said before. That was the first mistrial. The second one almost happened during opening statements where defense was doing the whole Denny thing, saying Sadie could have been the murderer or teamed up with somebody to murder him. And then we almost had another one today. They even brought up the word mistrial as the state, the district attorney says, basically, I need some time to think about this and see if we want to ask for a mistrial here or not. So yeah, I'm not sure if the jury is going to get to deliberate this case. We're going to see how it ends. It's crazy. Don't Interrupt Me was perfect. I'll have to find exactly where that is. I've got it on the recorder, so we're not going to miss it. Let's see. Was it the same prosecutor as this trial? Yes. This judge, obviously, he's been involved in some high-profile cases in the past. One of the ones that he was involved in, specifically when it comes to a mistrial or an appeal, in this case, was the Mark Jensen trial. That was the spicy trial. The antifreeze trial is one of the ways we referred to it as. In that trial, that judge allowed in the defendant's the victim's letter, the letter she had written before she died, saying, if I'm die under some weird circumstance, it's my husband. He allowed that letter in. That was overturned on appeal. And so on the new trial where it was heard by a different judge, and he was convicted again. Same result. But that actual trial and that letter was brought up in this one, as we've got some information possibly from the defendant that they wanted to bring in. He said that would be like a letter from the grave, even though it's non-testimonial. Lux Lobo says, I don't understand how Sadie has been able to be in the gallery this whole time. If you've gone over this already, I apologize. No, it's fine. Lux Lobos, the reason Sadie can be there, because what you're pointing at is they have what they call the rule, right? And the rule means that nobody can be in attendance. None of the witnesses can be in attendance while other witnesses are testifying. So they can't hear what other witnesses are saying. They can't be in the courtroom. Basically, you show up for your testimony and then you leave again. And they did implement that rule, but they put in some exceptions. And this is normal for them to do that. They put in exceptions for at least, I think, 4 people. One of them was Sadie. One of them is the mother of the victim, and we've heard from her already on the stand. I believe there's possibly an exception for the DA, because, yes, the DA has been called as a witness in this case because of that whole situation with him interviewing that woman and everything. He ends up being a witness, a lot like a detective would be a witness in an interrogation of a defendant. So he's on the list, and he's had to leave while she testified because he still might be called. So yes, it's a little bit like a circus, but that's why most of the witnesses will not be in the courtroom. They'll actually go out and bring them in, but a couple of them are allowed to stay, and they all have exceptions. T-Rock says, I'm lurking, missing you all. Shout out to Mod Squad. Chat, save my seat when I'm back. We will. Sorry, I've been absent. I have doctor's note. Lurking from my sick bed now. T-Rock's kept feeling better. Appreciate you dropping in just to say hi. This is a case to watch. Even if you're just lurking, this is a good one. Anytime, Stephanie. I'm glad I could help. Hopefully, you're able to either follow, to sneak a phone somewhere and watch and follow along, or catch up on the replay, because this is going to be a fun day this afternoon. Let's see. I want to say welcome to all the new subscribers. We have quite a few subscribers that joined us today. Thank you very much. I appreciate also those who become members who support the channel. If you'd like to do that, you're obviously. My wife and I, Mrs. Ari, and I would say thank you from the bottom of my heart. They can literally just watch your channel and see every bit of testimony. They could, Adam, but the judge. That's why the judge says. Actually, in this case, he told the lawyers they had to inform all the witnesses of that, but they're not allowed to watch any account of the trial. Or any, so they can't watch they can't read a news story tonight that's in the paper about the trial. They can't watch something like this, a live stream or a video recounting anything that happened. So they should not be watching any of this. Awesome, Stephanie, appreciate it. The sound effects you're hearing are various sound effects that we've gathered over several months of trials from various ones. The laugh you heard, the cackle, was from the Mark Jensen trial. That was the defense attorney that had a laugh like that in the middle of court when the judge said something funny. But those sounds are all triggered by you guys, the users. They start with an exclamation point and then have the name of the sound afterwards.
No dead horse go
and there's a couple more. Let's see. I'm watching this while doing schoolwork, says Diana. Hopefully, if you have any hard questions, just put them in chat, Diana, and we'll all just pool our heads together. And don't cheat, but we'll teach you how to reach the answer. Lee, we've got you for sure. Lurking at work, says Jen CFC. Wonderful, Jen. Glad you can take us with to work. Popping in to say what's up. Work schedule's been hectic, but I'm still making sure to stop in. Thanks, Always on the Go. You are always on the go. It's an appropriate name for you. Who's the guy sitting between Sadie and the mom? I believe that is the mom's husband. I do not know if that's the victim's dad, though. So I don't know if that connection is there. Let's see. Soswald, thanks for subscribing as well, becoming an addict. That's what we call it when you click the subscribe button. Welcome. Hope you love it here. Does anybody know how old the courthouse is? It's fairly old. If you look at the doors when they show the back of the court, just look at the wear marks on where the handprint goes as they hit the swinging doors to go in and out. It's had quite a bit of use. I think it's. I would be surprised if it's less than about 60 years old. That'd be my just gut feel. JM, you made it. Well, wonderful. Happy birthday, Samantha. Tomorrow. It will be Samantha's birthday tomorrow, I think. Let's see. I'm trying afternoon high, see if it goes. Hey, Ann, it got through. YouTube likes you right now. We do have some YouTube interaction on chat. YouTube moderates chat a little bit. Okay, they have a filter. And sometimes their filter catches people for no reason whatsoever. So if for some reason it's not working, feel free to reach out to me on the burner phone. I'm one of the few YouTubers that gives out my phone number on the internet. But it's a burner phone, consistent with being involved in courts and trials and criminal activity like that we like to follow. You can reach out to me on the burner phone if you ever have a question, if a complaint, criticism, or compliment. That works. There are some times we actually open up the burner phone to live phone calls, and you can call in and tell us what you think about the trial. Tell us which trial we should be following next, or things like that. So if you ever need that burner phone number, you can just type !burner in chat, and that will pop up. Let's see, the judge said 100-year-old building. Okay, so that's more than 60. Charlie came in with a gifted membership just to kick things off right here after lunch as we're waiting for the judge to show up. He's got about a minute. Let's see who got the I have to switch to live chat, not top chat. Sorry about that. Looks like Patricia G was gifted a membership courtesy of Charlie Peterson. Thank you, Charlie, and congratulations, Patricia. The wonderful thing about having a membership is you get to type !seat. And instead of sitting and watching trial from the back row, as most of you do, you can move right to the front row. We have a reserved seat for you. You get to see and hear everything without an obstruction in your view. In addition, you get to access all of the amazing emojis we have, and you get an amazing courthouse next to your name. So you'll see here Brooklyn has a beautiful aqua-colored courthouse next to her name, indicating her time spent as a member. And that changes colors depending on how long you've been a member. Who are the two guys on the plaque? The farmer and a railroad man. We were trying to figure that out during the Jensen trial, and someone gave me the answer, but I think it's a miner and a farmer. And we figured that out because of the tool implements next to them. I'm not sure if you can see that, sort of like just inside the shield, about their shoulder level. You can see the plow and the shovel and the pick. So I think that's what it is, and I think it sort of points towards some industry in the state early on. The funny thing is, I guess it just cut to the picture of who knows who, but the funny thing is that whatever it is on top of that, I'm not sure if that's sort of like an armadillo or a hog or what it is, right under the word forward at the top of the screen. What sort of animal is that? It clearly has feet. Maybe it's like a shrew. I have no clue. John Goldbergstein. I said a few weeks ago when I first joined, I'm a recovering addict myself, and let me say it's the worst thing I've ever gone through. Good to know that you and Chet are well as well. John, congratulations. We're with you as well. Hang in there. My channel name indicates recovering addict. My addiction was different. It was not a chemical addiction. I was addicted to video games, and quite honestly, it just about destroyed my life. Still like games, but I don't play them on the level I did before, and so this is a good addiction.
Talking about stuff that is not relevant.
I'm talking about all sorts of stuff that's not relevant. Thank you, la 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 lee. I appreciate that as you trigger that sound. It's a chicken. It's a badger. The animal is a badger, says Stephanie Willis. It looks like a rat with like a hog nose and a hockey stick tail. I mean, I've not seen badger. I have seen a badger in the wild, and then let me just say that's no badger. Yep, we can. John, 100% agree with you. Thank you so much. Encourage you 100% on your on the path to recovery and sobriety. Awesome. I'm with you 100%. Let's see. It's a badger. I think it's supposed to be a badger. Wisconsin is the badger
There's
state.
a lawsuit.
Forward, it states the state's motto. Forward, badgers. Forward is what it. Yeah. I don't know. You guys have weird badgers, Wisconsin. Can I just say that? I appreciate that. Charlie Peterson just gifted another membership. Apparently, Charlie's keyboard actually has a gift membership button that he accidentally pushes periodically. And Carolina Girl, you just received a gifted membership by Charlie Peterson. Thank you, Charlie, once again, yet again. Charlie's been a great supporter of the program. No, it's John. It's not your fault. It's my fault for choosing a name that clearly means that. I'm the one that led everyone astray. I appreciate the kind words, though, and I do have a lot of experience with family, both close and far, that dealt with addiction and are recovering from addictions. So I'm not that far from it myself. It's an anteater, Shelley. I agree. It's an anteater. Here's the courtroom wall. I'm pretty sure this is like a wallpaper on one side, and then you've got probably 15 layers of white paint on the other. Why no cheese on the Wisconsin state seal? I think that was an after, later down the road they started making cheese. You will not criticize our badger. Wisconsin is perfect. I apologize, Ivan. Please accept my humble apology. That is a beautiful badger. It is the best badger. My button is stuck. Don't tell my wife. Thank you, Charlie. Okay, so cheese came later. It is a pretty pattern. I like the courtroom. I like the architecture. I like. We've seen a lot of courtrooms where they're very new. Like you can tell it's like a new, legal building. A courtroom. For some reason, the name just escaped me. Like a county courthouse. It might be a brand new county courthouse. It's got lots of glass on the outside and things like that. We've seen courtrooms like that, and they just don't draw you in like these older courtrooms that just have so much history in them. Cajun Girl says, attention, I would like to gift a membership.
Now
Please
we're
tell
not
me
stolen.
how. Cajun Girl, it's harder on an iPhone. I'm not sure if you're on an iOS device, but basically down at the bottom where there's a little dollar symbol under the chat, you can click that and click on the membership, and it will give you some options there. But thank you. I appreciate it. Even if it doesn't work, thanks for the thought. We need lady attack lawyer sound bites. If you hear a sound bite that really works, if you could clip it, I think you're able to clip any of these videos and clip it and just send it to me on the burner phone, just the link or something. That would be fantastic. Okay, courthouse was built in 1925. Okay, my house, Jonathan, was actually built 10 years before that. It's funny because during the break, I ate a burrito very quickly. And then ran outside because we're doing demo work on the garage. And I helped rip the window out of the side of the garage, a huge bay window, like 9-panel bay window that needed to go. It almost fell out of the wall all by itself. I have to rebuild that whole wall. And I proceeded to get a whole handful of slivers on the back of my hand. And I think they're fiberglass slivers. So I'm going to have to get those out at some point. Okay, Wisconsin is perfect, says Brooklyn. We should be stuck with Florida cases if we didn't. We would be stuck with Florida cases if we didn't have it. Lake Michigan Triangle, is that like the Bermuda Triangle? I know they have some crazy storms up there, PFOG, and a lot of shipwrecks as well. Okay. You need to do a before-after photo of this garage. I've taken lots of before, after, and during. I'm just happy that we've found the sewer line and been able to tie in and replace after we hit the sewer line with the excavator. Oops. Yeah, that's fixed. Hope the internet was great, Michelle. Thank you very much. Okay, I think we're all caught up. Brooklyn, the one thing I'll say about the DEP trial was the good audio, the sound tech system, the ice cream case out of Florida. We saw another trial with that judge. That one also is a newer courtroom. Great audio, good camera angles. This one has some pretty good camera angles, but the audio is not the best. Get some duct tape for your slivers. Right here. It's actually gaff tape because, I'm a techie. But duct tape would probably work better than gaff tape. But I actually used a couple pieces right before I went live. Insurance guy, you could have helped me with what? Because if you offer, I just might accept it. Right now, I need an appraisal. If you have a good appraiser, Cajun Girl did just gift a membership. Thank you so much, Cajun Girl. Let's see who's going to get it here. It looks like Lindsay Hendricks. Lindsay Hendricks, congratulations. And thank you so much, Cajun Girl. I appreciate your support. This channel would not be the same without you here. Appreciate it. I want to pay it forward. That is awesome. You guys are amazing. We are caught up with the court, Nicholas. That's a great question. We were following the Murdaugh trial, the Alex Murdaugh trial, and there was a little bit of overlap. So we had a couple days where we had to catch up. We ended up watching the first 3 days of trial in one day here, and that was just by me cutting out all the breaks, speeding things up a little bit, and yeah, it was good. Liquid wax works better than duct tape to get the cactus needles out. Good. I've got tape on my hand. I'm going to pull it off here once it's got a good bond. But yeah, the slivers will go eventually. What games were I addicted to? What console did you play, and what was your downfall? How did it affect you? A lot of questions, but let me try to answer what I can before court starts. I was addicted to World of Warcraft. I played on a PC, and my slash played. That's how you check and see how long you played a game. In a very short time was measured in several months, and that's how much actual clock time, like stopwatch time, I've been playing the game. And the time that I was playing, it was more than all the time I was awake or sleeping. So I was living in that game, and it was awful. And Mrs. Ari brought it to my attention, and so I was able to quit. It was difficult, but I quit. I will tell you, there was a point where where I was so addicted, and people don't realize that you can get addicted to video games, but I was so addicted to playing a game that I found myself driving down the freeway with a laptop on an air card, with the game going on the seat next to me, and realized just how many lives that could have destroyed, least of which of my own. That was part of the lowest point. Let's put it that way. Was I any good? Of course I was good. That's why I played. I was in the world. It's called an MMORPG, a massive multiplayer online role-playing game. Looks like the judge might be coming in here. See, the throne is there. Anyway, it's a game where you level up to play the game, and I was the top I could be, and on the top at what I did in my little world. Anyway, that's irrelevant. I'm talking about things that are not relevant. Let's see. I could totally see video games being addicting. My son got a Switch. I got a Super Mario Odyssey as a gift for him, and then cut him out of his own gift.
You're talking about stuff that is not relevant.
Thank you, Judge Manning, for that. I'm a WoW nut, but I don't spend that long on it. That's good. I did not have the ability at that time. I can't go back to WoW because it's a trap. It's a trap I fall in. I do have a TikTok account where I do play games because I actually, on TikTok, I do have, what they call it, I've got representation. I've got an agent, I guess you could say, for my TikTok account, which blew up based on a viral video I made. But that account is steered towards gaming, and so I play other games, not World of Warcraft, but I play mostly Mac OS games and just funny short games, mostly with like my kids on that channel, just to keep my agency active. Check the burner. Hilarious screenshot sent your way. Oh no, is it a screenshot of me, Amber? Looking at the burner phone here. Oh my goodness. Okay, it's a meme. It's a meme of the, and it's a funny meme, but it replaced the names. That is funny. I'm not going to share it on the stream, unfortunately. Sorry I even told you guys about it, but that's good. You're welcome, Ivan. Ivan's also a great supporter of the channel. For those of you who don't know, Ivan Victor has a mini pincher, a mini pin, a little dog named Rebel that runs his life. She is she is the boss, and he also has a YouTube channel. If you like watching videos about cute little dogs, Ivan's dog is the one to watch. You can see it there in his little logo there on the screen. But if you search on YouTube and just by his name, Ivan Victor, just like you see there, just all one word, you'll see his channel. It would be awesome if you gave him a follow on that channel, subscribe, and watch a couple of videos. He's a good friend of the channel here. Okay. Smoking Lady says, and now I'm addicted to this. Well, this is a good addiction. Ivan says, check the burner. Sorry, it's got lots of messages coming in right now. Mini pin. Rebel, and it looks like glamour shots. I'm not sure if you guys can see this, but glamour shots of the dog. So, oh, that's awesome. Okay. Let's see. We're waiting for the judge. The judge might be a little bit late. He is, as a matter of fact. He's 13 minutes late, possibly because he talked 20 minutes through lunch. Ooh, somebody's right in front of the camera. Yes, if you want to see the meme that Amber sent me, her Vixen sent me, you can go over to Discord. Discord, we have a great partnership with the Discord channel called As the Gavel Drops. They are a true crime Discord page where they track every true crime case that's in progress, pretty much across the nation. Not everyone, but all the high profile ones. Everything you want to hear, it's going to be there. They have invited all the viewers here on this channel to go participate there. So Little Miss, Toxic Discord, Amber are just some of the great people over there that make that page possible. And you click the link here. If you ever need the link, you can just type !Discord in my chat when I'm live, and that link will pop up, and you can pop over there, and you can find things like the schedule for what trials are coming up, or you can see the latest filings. A lot of times we'll have documents from different court cases, videos that have been posted, you name it, it's going to be over there in Discord. So thank you very much for that. Suzanne just gifted a membership as well. Thank you very much, Suzanne, for that. It looks like Gator Gal was the recipient. Thank you very much, Suzanne, and congratulations, Gator Gal, on another month. That's awesome. Let's see. I think we're caught up. I think we're all caught up, and the judge is still not back. So the audio's on. So if something happens, we're going to hear it. Let's see. Brooklyn says, this has become such a stellar community. I'm a lifetime lurker. I never feel comfortable enough to insert myself. We do have fun here, Brooklyn. A couple times we'll have some disagreements as far as opinion goes, but at the end of the day, we're able to still be friends, which is just, this community is so much different than anything I've ever seen on the internet before, where we are civil to each other, where we, do have a good time. And just, I know so many details about so many of your lives, and you share them with me. I get pictures of everything that's happening on the burner phone, whether it's good or bad. A lot of times I'll hear from you guys about hard things you're going through, and it's very much a family type atmosphere here. So I do appreciate you all. Charlie just gets another membership, and it went to Ace of Swords 0. Ace of Swords 0, congratulations. I think that's a first membership for you. Welcome, and thank you very much, Charlie, once again. All right. I was expecting the judge to be back, and he's not, which, if I had known, I wouldn't have eaten my burrito so fast. We do have a little bit of an ASMR moment coming because I need to fill up my mug. I do have a little, it's one of the two items of merchandise we have. I've got a True Crime Addict mug that I fill up with water for the trial. Deer Park Water. I hope they sponsor the show one time, because I go through a lot of their water. So this is your warning. This is an ASMR moment. Here we go. And perfect timing. It sounds like they're coming. Well, they're playing with the mics, but I will not spill on my laptop. All right. The mugs are available in 5 colors. With the other item we have, if you're interested.
I did have just one question.
This mouse pad.
So, and this is just to prevent us from having the jury come back or have to leave at any point. So defense on cross so far of Mr. Campbell has asked the question of Mr. Campbell, did you assume that he had something to do with your friend's disappearance? The answer was something like, you bet, or something like that. And then the next follow-up question was, drove over an hour just to have a conversation with him? And his answer was, yes, I did. So I'm aware of the court's ruling on the hearsay. I'm just asking the court, and I don't want to make additional argument. I'm just indicating, does the court feel that that has opened the door in any way that allows admissibility of the things we talked about this morning? No argument.
That allows the
admissibility of the thing that I sought to introduce this morning. So in other words, did the fact that the defense asked those 2 specific questions cause any change in the court's hearsay ruling from this morning? And I'm not asking to be able to extensively argue it. I just know that additional thing has happened. So that he was directly asked those questions.
Thank you, Seven.
And so whether that changes the ruling on admission of hearsay on that topic is my only question.
Well, I'm actually going to invite comment on it. Did you want to respond?
Yes, thank you. The question's about the nature of why Mr. Campbell testified that it was simply just to go there, have a conversation with the guy. Those questions were offered to try to rebut his answer about that it was going to be a civil conversation. That's all the defense has to add, Judge.
She was trying to get at, she thought they had a gun with them.
The reason for him going there, which I believe was also addressed by the state, but his assertion was that it was just to have a conversation. My asking those questions was to show how to discredit his answers about his nature of him going.
And so my argument there is, they've now attempted to discredit an answer he was legally precluded from giving, right? So the court made a ruling, and now the response from the defense was to make it seem as if he failed to provide an answer and so is suspicious. So remember, I was only allowed to argue or to ask him a question where I said, well, did you go to a particular place? Yes. Whose place, right? And then he got the name. Now, defense has responded to that direct, where I was limited, and they said, did you assume he had something to do with your friend's disappearance, and you drove over an hour just to have a conversation with him? And of course, that's the direct allegation that they made in opening as well. And so now, again, the jury is left with this, that all that has been offered in direct is that he went there with no explanation why, and now there's been some assertions under cross that there is a aspersion, there's a reason that's dishonest in some way, right? And so now his credibility has been directly challenged when the actual honest answer is that he's legally precluded from offering the answer that would settle that issue, or would at least illuminate that issue.
Where's that sound from,
My
Rick?
understanding in direct, though, is that he had said that he was going to Zachariah Anderson's house, and then he said that the reason he went there was to talk to him about his friend's disappearance. So the defense then asking, you drove an hour out of your way to talk to someone that you thought had something to do with your friend's disappearance, is not anything new that I opened the door to. Rather, it was just calling into question his previous answers.
It's the two questions in sequence is my argument to the court.
But there was nothing
Jury's not
that
here
didn't
yet.
come up in direct. I didn't offer any new information, nor did the witness offer anything that I feel leaves the jury at a cliff.
Well, it's closer, but I'm going to leave it as it is. All right. Ready to go?
Yes.
So no decision there. Bring the jury. And no, Amber, I didn't forget. I think now's a perfect time.
Come down, please.
Okay. Mike. What day is it, Mike? Guess what today is?
It's hump day.
Hump day! It's Wednesday. Happy Wednesday to everybody. Sorry, I did forget this morning. It is Wednesday. Why does she keep talking about him being at a bank way out in Bangkok? Because she's trying to discredit the witness. He said he was in town, and apparently he was out of town. So that is a great commercial. I do appreciate a good commercial. I mean, going all the way back to like, where's the beef? I've really do enjoy commercials. Go give Rebel a watch. New video. Awesome. We'll have to check out the new video Ivan has on his channel. And I've got pictures. Maybe they're connected. He did cross state lines. He did, but he lives on the border, right? So it's just a few minutes away. No audio from the courtroom right now. Hoping they raise the volume here just a second. Bump day, as we used to call it. Yeah. Awesome, PFOG. I think most of us have some experience along somewhere. So, but just being there to encourage people on the day today, because that's all it is. It's one day at a time. I think that's great. Appreciate all you guys. Born a Hawkeye says, darn, my messages aren't going through. Did I miss one? Was there a good one? I've been scrolling really fast. I think I've got I think I have the slow chat turned off.
The defense has no further questions subject to recross.
State.
Jury must be here.
We have no further questions.
So the witness is
Campbell,
released.
you're
You may step down, sir.
He's shocked he can finally leave.
What was the laughing? He the way it ended, he thought he was going to be up there for another year, but Let's see who gets called next. If I can have one of the mods maybe giving the name of the witness so we can pin it at the top of the page, that would be great. The next one. Okay. Okay. Judge found an orange. I think we're waiting for the judge to do something. He did pull an orange out. He's peeling it right now. I missed it. I was looking at chat. I'll have to go back and watch what happened. Apparently the judge didn't get lunch, and so he's going to eat it now while we wait. Oh, man, Brittany, I'm sorry to hear that. Oh, man. Hope she can get back on the day at a time. The Man Bun murder trial. I've heard that. That might be a good name. Judge is going through the lunch
Raise your
break.
right hand, please. Do solemnly swear the testimony you are about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God. Please be seated. Oh, that's it.
Ms. Saylor, can you state your first and last name and spell both your names for the... I'm sorry, did we swear in? I apologize.
I did.
Oh, okay, sorry. Can we state your first and last name and spell both your names for the record?
Erica Saylor, Erikasaylor.
And Ms. Saylor, what town or city do you live in currently?
Kenosha.
And do you have any children?
I do.
How many?
3.
And do you have any children with a person named Michael Campbell?
I do.
How many?
2.
And as to Michael Campbell, were you back in May of 2020 in a relationship of some kind with Mr. Campbell?
Yes.
How would you characterize the relationship in May of 2020?
He was my boyfriend.
And where, if any place, can you tell me, did you reside versus where he resided in May of 2020?
We lived together.
And again, what city was that in, if you can tell us?
Kenosha.
She's the
Saylor,
previous witness's girlfriend.
Are you familiar with a person named Rosalio Gutierrez?
I am.
And how do you know that person?
He was a friend of mine.
And when did you first know him?
I met him about 16 years ago.
Okay. And has he been was he a continuous friend up through May of 2020, or was he a person you knew periodically?
No, he was a continuous friend.
Okay. And what, if anything, can you say about in the time period of May of 2020, whether he and Michael Campbell had any connections or were in any way attached, friendship, work, any of those things?
Both. They were really good friends, and they worked with each other quite often.
Now, I've indicated Michael Campbell. Is that a person you're in a romantic relationship of any kind today?
No.
Okay. I want to turn your attention to the weekend that happened just before May 19th. Well, let's start with May 19th. Apologize. On May 19th, a Tuesday of 2020, was there a moment that somebody brought you news which was worrisome to you?
Yes.
And what would be your best estimate, again, just an estimate, on what time you received that news and where you were?
I would say it was probably early afternoon. I was at home.
Okay. And who provided you news? I'm not asking what it was, but who provided it to you?
Mike.
And based on the news that you heard, did anyone else eventually arrive at your home?
Yes.
And who else do you recall arriving at your home, again, on that afternoon of May 19th, 2020?
Brandon Hendrickson.
Is that a person you already knew?
Yes.
How did you know that person?
He was a friend of ours.
Okay. And after both Michael Campbell and Mr. Hendrickson and yourself were at the residence, what, if anything, did you do to begin to investigate any matters?
I immediately began to look for information in regards to Sadie. I knew that she had been seeing Junior, and...
Let me stop you. So when you say Junior, are you referring to a person we've identified previously as Rosalio Gutierrez?
Yes.
So if you say Junior, that's who you mean?
Yes.
Go ahead.
I began to look for information to find out who Sadie was.
Were you ultimately able to figure that out?
Yes.
And if you recall, what source did you use? If you don't, just indicate in general.
Oh, yeah. I searched Junior's Facebook friends.
Okay. And ultimately, you found an individual you could identify as a person you believed was likely Sadie?
Correct.
Okay. And then at that point, did you have a name for that individual? If you know. Did you have other than Sadie's first name, did you have a
No, I only knew of her first name.
Okay. And then what further investigation, if anything, did you do after you received or after you found out that who Sadie was?
I dug through her Facebook, just trying to get some general information about her ex. And then after that, I C-capped her.
Okay, and did you figure out who the ex was?
I did.
And were you able to get a name?
Yes, I was.
And what name were you able to obtain?
Zachariah Anderson.
And in general, are you aware of what sources or how you figured out that her ex was Zachariah Anderson at this point?
Yes, so when I C-capped her, there was, I think, a few court cases.
Yeah, okay, I don't want to know the details, but that you did through C-cap?
Mm-hmm.
Okay. And ultimately, through C-cap, you were able to identify a name, and that's Zachariah Anderson?
Correct.
And at any point, did you do any further investigation regarding this person, Zachariah Anderson, in relation to where the person might live or any of those kind of things?
I wouldn't say that I did further investigation into where he lived because that information was in the public records that I found.
Okay. So at some point,
hey, John,
did
you're
you
good. Don't
have
worry about
in
it.
your possession
You're among friends here.
on the afternoon of May 19th, 2020, an address you thought was likely an address of Zachariah Anderson?
Yes.
And what did you do with that information? Did you give it to anyone? Did you just keep it a secret? What did you do?
I gave it to Mike.
And that's the person, Michael Campbell?
Correct.
And I don't want to know what was discussed, but after Michael Campbell received it, what did you observe happen next?
He left the house.
And did Michael Campbell leave with anyone?
Yes, with Brandon.
Okay.
I wonder if she's going to be asked if they took a
anyone else
firearm.
who are adults present when Michael Campbell and Brandon left your home?
No.
And what would be your estimate, if you have one, on what time they would have left your house? Again, only if you know.
I would say late afternoon.
Okay. Excuse me. Ms. Saylor, I'm going to now turn your attention to the weekend before this Tuesday the 19th. Okay? What, if anything, can you say about any memory you believe you have about contact with Rosalio Gutierrez on that day?
On
that weekend, I apologize.
We spent time with him that weekend at our home.
Do you have a recollection of what day that would have been? Only if you know.
No, I can't say exactly.
And do you have a recollection of who else was at the home with the three of you?
Our children.
Okay, meaning your children?
Correct.
And are you, other than your children and Rosalio Gutierrez and yourself, who else was present, if anyone?
Mike.
Mike? Mm-hmm. Okay, and were any other children present other than your children, your grouping of children?
I believe his children were there, but I honestly don't recall.
Okay. And do you recall what was going on in this situation?
Oh yeah, we were just having dinner like we would do weekly.
All right.
I'm not sure, Spotlight Spy, why they're getting into this.
Now, I'm going to turn your attention now to the Sunday evening, May 17th of 2020. In the evening hours, so dinner on, do you believe you recall who you were with, if anyone?
Yes.
And who do you believe you were with?
I was with Mike, my kids.
Mike Campbell?
Correct.
Okay, and kids meaning the three kids you mentioned?
Yes.
And where were you located?
In our home.
Okay. And were you able to look back through either your social media or your phone, any information you keep on your phone or any information you store to provide some information to you about what was happening around mealtime?
Yes,
And did you provide that eventually to the DA's office?
I did.
Okay, I'm going to show you a video. What? Oh, let's do that.
On State's Exhibit.
Mike.
Ask you if you recognize this as something you provided to the state, meaning the DA's office.
I'm going to object as far as relevancy and foundation.
What about just relevance?
Oh, yeah. Respond.
Yes.
She's indicated who was with her on the evening of the 17th. She's indicating she has a memory of that. She's indicating these videos contribute to her ability to remember that. So we're going to show these as to confirm that she's bolstered by the fact that she has reviewed these videos.
And she is what?
She's bolstered by the fact that she has found these videos and that they confirm her memory
So
that she and Michael and her children
I'm
were
not clear.
together.
Are you asking her to view them to refresh her memory, or merely to buttress the fact that her memory has been refreshed?
To show that they confirm the memory of what she remembers that day. So they bolster her memory, correct? They bolster.
So are you offering for her to look at them, or the jury to see them?
I'm offering them for the jury to see because they are the reference points that allow her to say, yes, on the 17th, this is what we were doing.
Yeah, Judge. She hasn't established that her memory is faulty in any way, so this isn't being done to refresh recollection that she's indicating she can't remember. And you can't bolster someone's memory of what happened before. I mean, first of all, we're not supposed to bolster anything, right? Yeah. But also, if it hasn't been established that she needs this to refresh anything about what she's testifying to, it's really not relevant.
If it were, and I'm still not clear.
Okay.
If it is being done to refresh her recollection.
It is not.
Okay.
So it's not admissible.
Well, you can't refresh her. You can bolster her credibility, but only after it's been attacked.
That's Nicole. You said that first.
So,
I'd ask that the image of the video be taken off the screen.
So here would be the example I would liken. If somebody says to you, okay, on this day, where were you? And you go through your social media and you say, I have reviewed my social media. Here's how I know where I was on this day and what I did on this day. Then I believe you can not only testify, here's where I was and what I did on this day, but you can say, here are the ways that I have been able to determine that.
But he didn't lay that foundation.
Otherwise, as the court can imagine,
how is it different from a witness who has a memory of something and then offers a document to substantiate the accuracy of the statement?
That's prior
consistent statement. If there's
no, it's not a statement.
Well, no, that's the prior recorded. It's prior recollection refreshed through the document itself.
Because she says the memory doesn't require refreshment.
The judge is on the defense side.
I think
they listen.
The objection that I had noted too was, I think we haven't gotten to that next step of whether she needs refreshing her recollection or if we're admitting the video as a past memory recorded.
No, that's.
But I think what my objection was to foundation as well, because the state hadn't asked her about where she was that evening, and then just attempted to just show the video.
The rules we've been talking about, and maybe I was the architect of the problem, deal with principally with statements. It doesn't have to be statements. It can be other things that are used in one instance to refresh recollection, which has been testified to be exhausted, or as a record of a past recollection. But there are also situations, yeah, I had dinner at the House of Gerhardt the other night. Here's the receipt. That doesn't fall into either category.
No, I think that would be permissible. That hasn't been done here.
Well,
the previous question is, that's why I had objected to foundation.
So again, the questions that have already been asked, okay, so the record is already in. I asked her where she was that day, who she was with.
Right.
And that evening. Now I'm asking whether this video is hers, and did she use this to be able to determine where she was, what was going on that day. So it is her, essentially what you just said. It's her saying, because I'm looking through my social media, I'm able to recreate this. Just as if you had a receipt, you'd be able to recreate it.
The normal and most direct way of asking those questions is to ask her what she was doing, if she remembers, and then if she has trouble remembering, then this may come into play.
And we have
there hasn't been any showing of relevance other than
arguing the same issue, which is weird.
To want to play it in front of the jury. And that's a separate issue, by the way, as to whether or not it's something that is relevant to a finding of fact that the jury would have to make here.
Well, unlike you, as I've said before, I haven't seen any of this before, so I have no idea. But if he's describing it properly, then it's it's a refreshment of recollection through a past recorded recollection, which is a kind of a hybrid. But I think it's admissible, just like my dinner receipt would be.
Okay. All right. And Judge, I'm just going to request that that you limit each of our counsel tables to only having one attorney per witness render objections or make arguments. So I just fear we'll never get out of here if you allow both attorneys on either side, or all three attorneys. We have 5 attorneys. I just would ask the court to make a simple request or perhaps an order indicating anytime there's going to be argument here on a particular witness, that one objects and one makes the legal rulings, and that we not go back and forth.
Well, I understand the time issue, but this is something that the rule exists principally for the protection of the poor reporter, and she's indicated, thus far anyway, it hasn't presented too much of a problem.
Okay. She's
so
amazing.
I'll leave it as is.
All right. Again, Ms. Saylor, were you able to determine many things about the evening of May 17th based on a review of some information you had in your possession?
Yes.
And particularly, were there 2 videos that caused you to have some memories that allowed you to recreate May 17th in the evening hours?
Yes.
All right. And did you provide those 2 videos that helped you recreate that knowledge of what happened on that evening with your family?
I did.
Okay. So now I'm going to show you again, and I've lost track of what it was marked.
State Exhibit 1, number 346.
State Exhibit 1, number 346, and ask you, is this one of the videos that you observed that allowed you to have a memory of how the evening went on May 17th? It's going to come up in a second. Okay, so is that you taking a video there?
That is me.
Of you essentially panning the food?
That's right.
Panning across the food. Okay. Does this refresh your memory about what you guys ordered for food that night?
Yes.
Okay, and what was that?
Shogun.
Okay, and were you able then to show us a time and date stamp on a separate document that verified that this video was from the 17th in the evening?
Yes.
Okay. So now I'm going to show you that, and counsel, if you'd say what that exhibit is numbered.
State Exhibit 1, number 347.
Okay, so is this again the video in question?
Yes, it is.
Okay, and can you see on there some sort of a time stamping that allows us to tell you what date and time that video was taken?
Yes.
And so what does this exhibit reveal?
It states May 17th, 2020 at 7:30 p.m.
Okay, and is that consistent in your memory with when this food was was served to your family?
Yes.
Okay. Now, do you also have a memory from the 17th of a performance taking place at your household?
Yes.
Okay. And I don't want to know the name of that individual, but can you indicate by sex and age who that person was back in May of 2020?
A male boy. Is that what you want?
Well,
you said by sex and age.
Son or daughter.
Okay, it was.
We're trying not to say names of minors out
Gotcha.
loud.
Yeah, no, definitely not. It was my son.
Okay, and what age was he in the video?
He was 7. 7.
7?
7 or 8.
And did that also provide you some context of this particular Sunday at your house?
Yes.
Okay. I'm going to ask you to take a look at that, and it's marked what?
States Exhibit 1, 3, 4, 5.
And then tell me as this is going on, is there a person peeking sort of in the background?
Yes.
Okay. Now, are you the one providing whatever the commentary is there?
That is me.
Okay. And did a person peek through a doorway in the background there?
Yes.
Okay. And who was that individual?
That was Mike Campbell.
And is the hairdo that we saw in that peek the same hairdo you recall him having on May 17th of 2020?
Yes.
So as I saw him, he appeared to have a shaven head?
That's correct.
Okay. Is that the hairdo that he had throughout May of 2020, or did you observe him to change his hairdo at any point during that period of time?
No, that's the hairdo he's had as long as I've known him.
Which is, what, shaved? He was like bald, right? Since 9th grade or something? So all this is doing is putting Mike Campbell at the location at a certain time. That's how I'm getting out of this witness, this testimony so far.
I have no further questions, Your Honor.
Good afternoon. That last video we saw, you didn't have a timestamp on that one?
I mean, there is one. I don't know that I provided that.
Okay. And then the video of the sushi, had you gone out to eat?
No.
Okay, that was at home.
Correct.
Okay. And then the state had said you had provided that to the district attorney's office?
Correct.
That was just recently, correct?
I would say, gosh, to be honest with you, I don't recall when I sent that to them. It may have been last year. I don't really remember. It may have been earlier this year. I don't recall exactly.
But it wasn't in May of 2020?
No.
You didn't speak to detectives in May of 2020?
No, I did not.
No one ever reached out to you?
No.
Okay. May 17th in the early morning hours, like 1 to 2 a.m., do you remember where you were then?
I believe I was at home.
Sleeping?
Could have been.
Yeah.
Yeah.
Early. Do you remember, okay, so that would have been like really early morning Sunday, that Saturday. Do you remember what you had done on that Saturday, May 16th?
No.
Okay. You have no recollection of going to a bar or anything like that?
No, not that I can recall.
And in these videos we were shown about around 7:30ish on May 17th, 2020, you said Mr. Campbell was with you during those times?
That is correct.
Do you know did you have any information or did you make any observations of where Mr. Campbell was the very early morning hours of May 17th around 1 to 2 a.m.?
No.
And the very late night hours of May 17th, 2020, do you have any information of where he was?
I'm going to object as to vagueness. So May 17th at what time would be my request?
Okay. She's going down the same path. We're gonna end in a big fight here at the end.
That's for your request.
If this is allowed.
Okay. Overruled.
You can answer it, sorry.
Okay. Please repeat the question.
Sure. The very late hours of May 17th, so midnight, early morning hours, 1 a.m., so of May 18th. Mm-hmm. Did you observe where Mr. Campbell was?
No.
No further questions.
So you had the sushi on the evening hours of the 17th, correct?
Correct.
Did Michael Campbell leave your home after you had the sushi on that day, on that evening?
No.
Okay.
No, he did not. I think I misunderstood your date. Sorry.
Now that you understand the question, does that, 11 p.m. on the 17th, the same night you had the sushi, where, do you know where Michael Campbell was?
Yes, he was at home.
Okay. Midnight on the same night you had the sushi, do you know where he was then?
Yes, he was at home.
Okay. Nothing else.
I'm going to make just a limited recross. Were you sleeping during those hours?
Could have been. I'm not sure.
So based on just what your observations are, you cannot definitively state during all those hours from, let's say, 12 a.m. or let's say 11 p.m. on the 17th all the way through, let's say, 6 a.m. on Monday, May 18th, you didn't make any actual observations if you were sleeping?
I'm a really light sleeper, so we were home in bed. If he would have left, I would have woken up from that. So.
No further questions.
Nothing on that.
You may step down, ma'am.
And she just broke the whole witness stand while she's up there. Ash Axiom, thank you for gifting a membership. That one went to Lux Lobos. Congratulations, and thank you both. We're not on fast forward anymore, Debbie. This is real time. This is happening right now. Congratulations, Lux. Let's see. But no dead horse go unbeaten. I'm surprised she didn't dig that a little bit further. She was trying to get in where he was at. Where was your boyfriend?
So it's with Huggy, that's
during that time.
You're talking about stuff that is not relevant.
Hey, it was some good sushi apparently. I've never been there. I do like sushi when it's cooked. I have a hard time with raw food, raw fish. Just, I know there's probably a whole world of tasty food out there that I have not tried because I like my food cooked. But Debbie, I can't fast forward at all because this is happening right now. So my time machine is broken. Spicy too. I'm California roll right here. Spicy California roll, a little bit of wasabi. I'm all over that. Isn't pointing the finger at Mike and what the near miss trail was about a moment ago. Didn't defense counsel violate the Denny order? Yes, they're approaching that again. They didn't get as close as they did last time, Nicole, but they were basically doing the same thing. Like last time, they were saying basically it's like, where were you at the time of the murder? Is what they did to Mike, right? And that's what the judge shut him down for. That's the very problem they had with Denny during the opening statements as well, where they did the same thing to Sadie. And now with Mike's girlfriend on the stand, they're like, where was Mike at the time of the murder? Yeah. The Aliard, the Aliard, I don't know how to say your name. Shogun's is so good. Love the hibachi chicken, and fried rice is top tier. I have to say that maybe I'm a lesser class person, but I'm a huge fan of Panda Express. There, I said it. Panda Express. I do it. That's my go-to for Chinese, and I realize it's not real Chinese, but I have a hard time with sushi. But I like the reason why I went to the Panda Express with Chinese is the rice they have there. I'm in love with as well. Raw oysters is all eat raw. I cannot do that. Oh, I've never tried it, but I don't think I could. Love the spicy salmon rolls. Broiled salmon. Who was it that's saying you cook something on a board for 2 hours and then you throw the fish away and eat the board? What fish was that? Was that pike? Debbie's working on a time machine.
Calls Ronald Watucky to the stand.
Ronald Watucky.
Raise your right hand, please. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please be seated.
Mr. Watucky, can you state your first and last name and spell your last name for the record?
Ronald G. Witucki, Witucki.
And how are you employed?
I work at the State Crime Laboratory in Milwaukee.
How long have you been so employed?
A little over 35 years.
And what's the nature of your employment at the Wisconsin State Crime Lab in Milwaukee?
I work in the DNA analysis unit.
How long have you worked in the DNA analysis unit at that agency?
When I started at the crime lab, like I said, about 35 years ago, we did not have a DNA analysis unit. We initiated the DNA analysis unit in the mid-1990s, so I was part of the unit before then, but I've always been a part of the analysis unit, the DNA analysis unit.
So, in summary, how many years have you been a person analyzing DNA?
That was Ivan on the phone. He was just saying all these witnesses are liars. I've been around them a long time.
Probably about 30 years.
And
this is the DNA stuff.
What
Let's see how this goes.
Sort of, first of all, education do you have to be able to get that position?
In 1982, I graduated with a Bachelor of Science degree in medical technology. I worked about 4 years in the clinical laboratory as a medical technologist. At that point, I went back to school and later received my biology major. I began work at the crime lab in Milwaukee in January of 1988, and I began a 6-month training program in forensic serology. In October of 1988, I attended a 2-week training session excuse me, on semen identification techniques at the Serological Research Institute in Richmond, California. In November of 1990, I attended a 4-week training session on DNA typing methods at the FBI Academy in Quantico, Virginia. And as I said, in the mid-1990s, I was part of the validation work that allowed us to implement the DNA typing technology into the crime laboratory and apply it to our casework. I took graduate coursework in 1997 in human development, anatomy, and biochemistry. I attended a 1-week training session on PCR DNA typing methods.
If I could interrupt, and have you continued, without needing to detail each one, have you continued to stay current in the field and continued to educate yourself and get trainings consistent with your profession?
Yes. Each year we're required to take 8 hours of continuing education on a DNA-related topic, and I've also done that.
And in your capacity as a DNA analyst at the State Crime Lab, during that those several years as a DNA analyst, do you have an estimate on how many samples that you have performed tests on to determine whether DNA was present?
Well, I never keep a running total or track of it, but it would have to be thousands at this point in time.
And did you test some samples and prepare a report dated August 8th, 2022 under a case name Rosalio Gutierrez?
Yes, I did.
And is that a case name at the lab that originally had a different DNA analysis or analyst do some work on that case as well?
Yes, that's correct.
Okay, so you were a second analyst brought in to do some additional testing, would be my understanding, is that correct?
I think that's a fair statement, yes.
And in the conjunction with the items you tested for possible DNA, did you prepare a report, again, dated August 8th, 2022?
I did.
And did you provide some conclusions within that report about the things you tested?
Yes, I did.
And do the opinions you offer that in a report, and in fact the opinions you offer in your testimony today, are you offering those to a reasonable degree of scientific certainty?
Yes.
I'm going to show you what's been marked as State's Exhibit 44. Just for purposes of the record, could you indicate, is this a copy of that report of August 8th, 2022 that we've talked about so far?
He turns each page with much force. It's like, whew, almost rips the page.
Yes, it appears to be an accurate copy of the report that I prepared and issued on August 8th of 2022.
So you anticipated my next question, which is it a true and accurate copy of the report you prepared?
Yes, it is.
Any changes or alterations you see other than a sticker on it that has a number?
No, correct.
Judge, I'd move admission of the exhibit.
Is there objection?
No.
Received.
I'd like to go through your conclusions on that exhibit briefly. Ask, did you take a look at an item that that is described as item AU, a piece of clothing described as jeans?
Yes.
And was that something that you were asked to determine whether there was the presence of blood?
Yes, it was.
And were you able to figure out whether the presence of blood were located on that pair of jeans?
I looked for blood. I could not identify any blood on those pair of jeans.
And were you able to identify DNA on those jeans?
There were a couple of stained areas that I extracted for DNA, and I did find DNA in both those stains.
And ultimately, were you able to compare that to a profile of a particular individual?
I compared it to several profiles. There was one matching profile for for the jeans. I compared it to several individuals, but none of those were matches. They were all exclusions.
So as to the match, was that an individual identified to you as Zachariah Anderson?
Yes. With my testing, I assumed since that was the individual associated with the jeans or that they were taken from, that his DNA would have been present on there.
And in your lab world, when you say associated with and you're talking about jeans, you mean who wore them? Would that be our normal phrase for that?
Yes.
Okay. So you would anticipate the person who wore them would have DNA on them. Is that right?
Correct.
Okay. And did you confirm that was the case in your results here?
When I looked at the profile, it was a mixture. And the types that I found, the types that were present were consistent with the person that they were from, Zachariah, but also there was another person, and when I tried to figure out who the other person was in that mixture, all the standards that I compared it to, they were all exclusions. In other words, no one explained who the second contributor was.
And just for purposes of the jury knowing, one of the people that you looked at who were excluded, meaning they were not the source of that DNA, was the individual Rosalio Gutierrez. Is that correct? So his DNA was not detectable on the jeans.
That's correct. Okay. He was an exclusion as being the second contributor for that stain.
So to this point in time, the second contributor is unknown to you. Is that right?
That's correct.
Okay. Now I'd like to go on to an item that you identify as item AV, and that's labeled in your report as swabbing recovered from the exterior door north side. Did you conduct a test on item AV?
Yes, I was able to determine that there was blood present on item AV.
And was blood present?
Yes.
And then did you attempt to indicate whether that DNA had blood that was appropriate for comparison with the DNA of the other persons that you had samples of?
Yes, I compared it to several individuals, and there was only one person that came back as a match.
And does that mean that person would be the source for purposes of your discussion?
In my opinion, they were the source of that profile.
And who was that individual? Who was the source?
That was Rosalio Gutierrez.
Okay. And again, that was blood, and it was the exterior door north side. Is that correct?
Correct.
And the label? Okay.
Correct. That's item AV.
I'm going to show you this has been marked as State's Exhibit 86, and just confirm that that packaging appears to be the same sample that you tested, and again found to be the blood of Rosalio Gutierrez.
86? 86. Was it previously admitted?
Yes, it is. It has our laboratory case number, it has the item designation letter, and it also has the date and my initials on it.
So that is the sample that you've just testified to in terms of results?
Correct.
Okay. Now I'm at item AW that is indicated as a swabbing recovered from the interior door. Did you take a look at AW?
I did.
And first of all, did you try to determine whether there was blood?
Correct.
And how did you, what if any result did you get?
Again, I was able to determine that there was blood on that item.
Then did you do further testing to see if it was appropriate to see if anybody's DNA matched?
Yes, I was able to do, again, DNA typing on there, developed a profile that was usable for comparison and compared it to a number of individuals.
And did it result in a match?
Yes.
And who was the match?
Again, there was only one match, and and that person that it was matching to was Rosalio Gutierrez.
Now, when something is blood like that, is the single match idea? Is that what you would expect to have be the result?
You mean like a single source profile, or?
Yeah, as opposed to skin cells and those kind of things where there might be more mingling. Is blood a logical place for you to get a single source profile?
Probably that would be the tissue that yields a single source profile the most often for the cases that we work.
So no surprise that you got single source on blood?
No.
Okay. I'm going to show you then what's been marked as State's Exhibit 84. Ask you, is that the packaging for AW that you just testified
to? Rock Mike, that's the question. Where was this guy on May 17th? It could be anybody. Let's ask everyone the question. I think the DA
yes, it is. Well. And again, this has our laboratory case number, the item designation letter, which is AW. And I've also placed the date and my initials on this item.
Then as to item AX, which is described as swabbing recovered from the middle seat cushion of sofa. Did you conduct testing on that first to determine whether it was blood?
I did.
And what, if anything, can you say about a result in terms of determining it's blood?
Once again, that was positive for blood.
And then were you able to compare the known standards and see if you could find a match in terms of DNA?
Yes. Again, I did a comparison to several profiles.
And were you able to get a match?
I did.
Who was your match?
Again, the match came to Rosalio Gutierrez, and the other profiles were not matches.
That was, again, a single source?
Correct. Well, that one actually gave a major profile, and there were a couple of markers that showed up very weakly. So I still came to the same conclusion as far as the major profile. There was those two additional markers that were some sort of very minor, trivial component.
Okay.
And that minor component was of such little information, it was not useful for comparison purposes.
Thank you. And so I'm going to show you what's been marked as State's Exhibit 83 and ask you, is this the packaging for what you described as sample lab lettering AX? And is that, in fact, the packaging for the sample you just testified to the results of?
Where all these answers are going to be the same. All the blood in the apartment was the victim's.
It is, and again, it has
I wish they could just batch them together.
All the markings that I described previously. It has our laboratory case number, our item designation letter, and then I've written my initials along with the date on the packaging.
So that, in fact, is the packaging for item that you've identified as AX, correct?
Correct.
Now I'm going to turn my attention to item AY. And that's labeled swabbing recovered from the living room ceiling. First, did you test that for blood?
Yes.
What was the result?
Again, I identified blood on those swabs.
Did you then test it for DNA?
I did.
What was the result?
Again, I developed a single source profile for those swabs, compared the profile to the profiles that I had for comparison, and they were all eliminations except one was a match, and that was from Rosalio Gutierrez.
And again, so this was blood, and it was the DNA of Rosalio Gutierrez?
Correct.
All right. I'm going to show you what's been marked as State's Exhibit 82 and ask you, is this the packaging for AY that you have just testified to?
Yes, it is. And again, it has all the markings I described before, the laboratory case number, the item designation letter, and I've written my initials and the date on the packaging.
Now I'm going to turn your attention to item AZ, and Judge, there's only one other one after this, so this is the last of two. As to AZ, identified as swabbing recovered from the tabletop, did you first test that for blood?
I did.
And when you tested that for blood, what was the result?
Again, I was able to identify blood on those swabs.
And then did you attempt to see if you could match it in terms of DNA?
I did.
And what was the result of that attempt?
Again, I went through the same comparison. I have found only one match, and that match was with the profile from Rosalio Gutierrez.
I'm going to show you it's been marked as State's Exhibit 78. Ask you, is that packaging consistent with what you've just testified to in terms of the sample utilized to make the determinations you just talked about?
I'm pretty sure I'm not eligible for the $200,000 settlement.
And again, it has all those markings of the lab case
water.
number, the item designation letter, and I've written my initials as well as the date on the packaging.
Finally, I'm going to ask you to take a look at item BA in terms of your report. Is that, first of all, identified as swabbing recovered from the kitchen counter? Did you test that for possible blood?
Yes, that's from the kitchen counter. I tested it for blood, and again, I identified blood on those swabs.
And were you able then to test that for DNA?
Yes.
And so whose DNA was that, if anyone's, in terms of a match?
The profile, again, I compared to the profiles from different individuals. Again, all were exclusions except one matched, and that was from Rosalio Gutierrez.
So
it's funny that he has a report he has to read off of.
I'm going to ask you finally then to take a look at State's Exhibit 88.
Because all the results were identical, pretty much.
Is this packaging consistent with item BA, the sample you just talked about the results?
These are all blood swabs from the apartment that he's talking about here. I don't think he's talking about anything DNA-wise in the genes.
Yes, it is. It has our laboratory case number, that is designation letter, BA, and I, again, have written my initials and the date on the packaging.
I can tell you about those when we get a break here if you want. I think that's separate.
So I've showed you a number of packagings. Mr. Witucky, are you able, what if anything can you say about whether you're confident those packages are the same? I mean, you haven't opened any of them. So are you confident that those packages are the same items that you conducted the tests on that we are talking about, and why? Without opening them, how do you know that?
Well, first of all, when we look at an item of evidence, the laboratory case number with the item designation letter label is placed on that package. And immediately when I take control of the package, I place my initials with a pen and the date that I took control of it. And then when my testing is complete, I repackage the item, reseal it, and The tape that I used to reseal the paper packaging, I again placed the date and my initials on the tape and the packaging, so that if there's any tampering, you'll be able to tell that someone had opened the package after I was done examining it.
So looking at each of the packagings individually that you examined, was that one of the things you were looking for, whether there was any manipulation or change in the packaging from what you would anticipate?
That's correct.
And so based on that, are you able to express confidence that each of the exhibits I showed you are in fact the actual items that you've testified to and written a report about?
I am confident.
Now, Mr.
Now,
Witaki,
the missing guy,
his
blood was found all over the
peer
missing guy's
reviewer
apartment.
On any of
One
the
drop inside
reporting
the defendant's
that
vehicle.
was previously done by Lisa Treffinger on the same case?
Yes.
Okay, so I'm not going to go through the results with you, but when you peer review, what is it that you do at the crime lab to make sure that someone is accurate, or what's peer reviewing in the process that you were doing with Ms. Treffinger on the previous reports on the Rosalio Gutierrez case?
I guess I'm going to object as far as relevance, given that Lisa Treffinger's report's already been submitted into evidence without objection. I don't think it would be not relevant and cumulative to have him testify to Analyst Treffinger's report.
Well, I assume that at some point that there will be some disputing by the defense that Ms. Treffinger's conclusions in that report and regarding whether this item is blood, but also the details of the report may be challenged, and so this is the peer reviewer. So I wasn't going to ask each conclusion. I was just going to ask, what do you do to peer review, and did you have any issues with this report Ms. Treffinger did as her peer reviewer? And did he? I'm sorry. I apologize. I just took a breath. And did he review the same materials to check her conclusions?
And Judge, to that point, the test that would be in dispute that the state's referring to was not a test that was actually conducted by Lisa Treffinger. Item A1 was not tested for blood. It was just DNA. And so there is no blood test to be refuted. I think that her report that's been submitted, it's already been admitted into evidence, can speak for itself.
Are you saying there's no dispute and will be no dispute as to...
There's a dispute to her opinion, but it wasn't an opinion that was included in her report. So that opinion was not something that Analyst Witaki, I apologize if I'm mispronouncing the name, peer reviewed, because it wasn't a test that was completed as to whether the presence of blood was existed.
The objections will rule.
Okay. So, Mr. Witaki, did you peer review the actual testing done by Ms. Treffinger in her report that I'll show you now, that is State's Exhibit 39?
He's not reading that fast.
Yes, this appears to be the copy that Lisa prepared, issued March 29th of 2021. And I was the peer reviewer, and I know that. Not only do I remember it, but my initials and date are on each of these 6 pages of the report.
When you peer review, are you aware of the entire process by which determinations are made or opinions are rendered by the crime lab? Or is it just the print in there, or is the entire decision-making process part of your peer review?
So what happens at the crime laboratory in any section, not just DNA, is that any report that is issued and is sent out of the crime laboratory has to be peer reviewed. And a qualified peer reviewer is a working case analyst that is knowledgeable and, as I said, qualified to do work in that discipline, in this case DNA. So I was the reviewer in this case, and my job is to look at all of Lisa's notes, all the data she's collected, all her testing results, and then verify that her conclusions are based on scientific data, that they're sound, and that they're reasonable conclusions for the evidence or the data that she's collected and the answers that she's taken from those from the data.
So that involves you reviewing her notes?
Yes.
It involves you reviewing her actual results in terms of any chemical testing or DNA testing?
Correct.
In this case, did it involve you reviewing the photographs taken by the crime lab?
Lisa showed me the photographs of, well, not photographs. It was a photograph of, I believe, item A1A, which was a tiny dark spot that was collected from a van.
And was that part of your peer review of her findings?
Yes.
And were you aware in your peer review of a decision made based on any factor not to conduct any chemical testing to determine whether the item that they identified was blood? Were you aware that that decision was being made by the crime lab in this case?
I was aware of that decision, and I would say that any crime lab in the country would have probably taken the same path, that when you have such a small amount of material to work with, you don't want to risk losing the DNA evidence to trying some other tests that may use up all the sample or a good portion of it, that you don't get a result or a DNA result later on.
Involved in your peer review process, were you reviewing the judgment by Ms. Treffinger that the item identified on the van as A1 appeared to her to, by visual observation, be consistent?
I'm going to object. That is not an opinion in her report.
I indicated her overall assessment. If he peer reviewed,
I didn't hear you.
If he peer reviewed her opinion that upon visual observation this item A1 was blood, did he peer review that?
What? Excuse me. Item A1 was what?
Was blood. Did he peer review that particular opinion offered by her or conclusion offered by her at the crime lab?
And again, that is not an opinion. That is not an opinion or conclusion that was included in her reports or any findings that I could note other than her testimony in this court. So I don't believe this analyst could have peer reviewed an opinion or a finding that was not documented.
Well, I believe he has.
Let him answer, and then you can cross-examine.
So, do you understand my question?
Could you state it again, please?
Sure. Is part of the peer review process that you have conducted in this case to render an independent judgment about whether the sample, A1, visually appeared to be blood by appearance?
I guess I'm going to object that misstates the prior witness's testimony about how she came to her conclusion about that dot allegedly being blood. She didn't base that on the appearance. She based it on the other factors that I don't really want to go into much more.
Her first decision, her initial decision, was based on her visual observation, and as the court will recall, it's bolstered by her scientific results. So right now I'm asking, based on his visual observation, does he agree or disagree with her original conclusion, subject to further information?
Well, she's saying that's not what the evidence was.
I can ask him his independent view, if you wish, what his independent observation is of it.
Well,
I believe I have fairly summarized her evidence. If I guess it's subject to cross if there's a disagreement.
You feel you're knowledgeable sufficiently to answer the question?
I can offer an opinion as to what the stain may or may not be, I don't, as was stated, Lisa didn't put in her report what her opinion was as to the source of the stain.
Will the defense win this one?
But I can offer an opinion if that's the question.
Is the opinion that she offered to us in our courtroom, is that a decision that was discussed in peer review?
Judge, I'm going to object.
Can I finish?
No.
We don't know. He wasn't here for her testimony.
No.
Correct.
I believe this particular opinion is one he has peer reviewed. The opinion offered by her.
No. That's not what your question inquired. Your question was, is the opinion she gave here in this courtroom? And he wasn't here.
Absolutely.
Rephrase your question.
Yep. Did you peer review a decision by analyst Treffinger that the A1 appeared visually to be blood?
I wouldn't say I peer reviewed that. I would say that based on what I know and the appearance of the stain that Lisa was able to provide to me, that the proper decision was made that this had the appearance of possibly being blood, and that she forgoed the testing that might allow you to determine whether or not it was blood, with the hopes of gaining the DNA knowledge rather than risk losing the DNA and just saying, oh, this is blood, but now I don't have any DNA profile for comparison.
So, based on peer review, you agreed with that call, with that decision?
I'm going to object. He didn't peer review that opinion, and he's already stated that he didn't make a peer review of that as it wasn't a finding in her report.
What?
He just offered his own opinion.
Well, is he a peer?
Sorry, what?
Is he a peer?
Yes.
Well, can he give a peer review right here in the courtroom?
He wasn't present for everything that she had mentioned, so no, because he wouldn't be able to
saying what she
to
said.
make a decision based and testify based on what she provided, because that opinion she provided, Judge, the first time we heard that was in this courtroom. That was not documented anywhere. So it does not exist in any other form or fashion or any notes. So gravely attempting to go down this road Attorney Gravely, it would not be appropriate given what's already been testified to and the fact that her opinion was only stated in court.
So, Judge, this is something the court has heard us talk about several times. It was talked about more than a year ago in public proceedings. It's been talked about numerous times. This is not new information. This conclusion that we're talking about is not a brand new conclusion to the defense. They've heard this, and the court has heard it several times. So,
what I'm most interested in is whether this witness believes himself to be qualified under scientific standards to conduct a peer review of what was reported in this case by Ms. Treffinger.
Trevor.
Yes, the answer to that question is yes.
And is that something you could do forthwith? Immediately?
Well, I peer reviewed all of Lisa's work on this case. So before the report goes out, the peer reviewer needs to agree with all of Lisa's conclusions that she's written down in the report. So I agree with everything that's in Lisa's report.
okay, so what we've said, though, is that what is not in Lisa's report is the additional opinion offered that the item tested A1 appears consistent with blood evidence based on scientific findings and observations. Are you able to offer a peer-reviewed opinion about that particular thing, knowing that's not specific in the report? Are you able to offer that peer review?
Yes.
Okay, so that is my question. What is your peer review conclusion, and what is it based on that would lead you to be able to render an opinion, yes or no, about whether you as a state crime analyst believe A1 appears to be blood?
So this stain A1, I asked Lisa if she could provide me a photograph of it, and she did, and she showed it to me, and it's a very, very small stain. And as I stated previously, this was absolutely the right call to not do any presumptive testing for blood and save this precious amount of sample, because it's very limited, and put it all into the DNA typing procedure, which is what happened. And she was able to develop a lot of information from this DNA profile. Now, the question is, what is the source of that DNA? So, with the typing procedure and the results that we obtained, we know that tissue from A1 is human tissue, but we were not able to do any testing to determine what the source of that tissue is. However, this tiny little dark-colored speck or splash is not consistent with semen. It's not consistent with saliva. It could not be a hair. Could it be skin cells that are providing the DNA? And again, I would say no, for a couple of reasons. One is skin cells are what we call touch DNA that sloughs off your hands as you handle objects, is not a very good source of DNA. And while there wasn't a lot of DNA in this sample, it did yield a relatively intense profile. Again, not real strong, but not really consistent with just incidental contact or touching. However, the most reasonable explanation, given the color and the appearance of this tiny little speck or splash, is that it's blood. And as I stated previously, the DNA testing shows it had to have been human tissue.
And is the photograph, you're saying you reviewed a photograph that was essentially a photograph while this speck was still in a van?
Yes, that's my understanding.
Mike, are you looking for a copy of the photograph?
Okay, so
I'm going to show you a picture and ask you, well, no, that's right. So it was a picture of a speck, a crime lab picture taken of a speck in the interior of a van. Is that right?
That's my understanding, yes.
So I'm going to show you what's been marked as
315 on Exhibit 1.
Exhibit 1, 315. It's going to come up here on the screen.
It was a very good answer. It was very good for the state as well.
Is that what we're speaking of?
It looks like the photograph Lisa showed me.
Okay, thank you.
We'll see what the defense can do on the cross of this guy, because this is what they're going to hit him on.
Now, again, the opinion you just described as sort of a peer reviewer of this item, are those opinions you offer to a reasonable degree of scientific certainty?
Yes, I would say in this case it's based more on my experience at the number of cases I've handled, I've screened, and I've worked over the years involving blood.
And you described this picture or this speck that you talked about as a splash. Why do you use that term, just so I know?
Well, it was so small, and you might, I guess, wonder how did it get there. To me, it had the appearance of.
I guess I'm going to stop, and this is asking for an expert opinion in the appearance of a stain, and I don't believe that, respectfully, that this witness's qualifications in that regard have been established.
You can cross, and if that develops, then I'll
Judge is on his
take
phone.
a remedial measure. Go ahead.
Go ahead.
Based on the appearance of it, it looked to me like it was something that would have sprayed or splashed and landed there and then dried, that it wasn't some sort of application or brushed on or that type of thing.
When you say application or brushed on, what does application mean? Does that mean the same
I guess I'm going to object again. This is going into now expert opinion on stain pattern analyses that hasn't been established if the state or given notice of as it relates to this witness. And if the only thing he observed was that particular photo, I think that's another issue.
I don't know that Mr. Gravely had finished his question.
I just wasn't sure what the word application means in the way he used it. That was.
Did you finish your question?
Yeah, that was my question. Yeah, what does application mean?
Okay. The objection's overruled.
Probably very similar. It didn't look to me as if there was any appearance that it had been brushed on or some sort of applicator was used. It just looked like it had landed there.
So defense is going to have a story for how this DNA got in the defendant's van. And I think they will even be able to present a reasonable story about how it got there.
I have no further questions of Mr. Witucky. Thank you.
Let's see how vigorously they do this cross.
When Attorney Gravely had asked of your opinion of your peer review of Analyst Treffinger's opinion about the source of that stain or what that stain was, you said that it was more based on your experience opposed to scientific certainty, correct? That was your answer?
I think that's a fair statement.
That means it's not expert opinion.
And is it a fair statement because that was never actually tested to be blood?
That's correct.
And in order for something to be scientifically certain in an analyst world, if you're going to say something is what it is, it's important to have the testing to back up that assertion, correct?
Correct.
And so in this case, there was no test that said that stain was blood.
That's correct.
You talked about your observing of the stain. You did not observe that stain in person, correct?
I did not.
And you weren't able to look at the stain under a microscope, correct?
Correct.
You were limited to the picture that was just shown on the screen.
That's correct.
And you'd agree with me that it is hard to determine or make an actual determination solely based on that photo to be able to characterize and make a complete determination about the stain pattern.
That's a fair statement. Lisa did magnify it for me, so I was able to observe the edges and the overall surface texture. But you're right, there are limitations to viewing a photograph.
Some of those limitations have to deal with the angle that the photo was taken at, things of that nature.
Yes.
I want to go back to the State's Exhibit 44. Is that still, did the state hand that to you? It was your report?
I did. Yeah, it should be.
Okay. So you had testified about some swab that you had extracted for testing correct, as it relates to a pair of jeans?
Yep.
And you
Correct.
you had known that those jeans belonged to Mr. Anderson.
That's what I was told, yes.
And you were told that by whom?
I believe it was on the inventory sheet as to who they belong to.
And on the inventory sheet, it tells you, hey, this is really a very casual way of putting it, but hey, can you see if you can find, these are the interested parties, this is the suspect, this is the victim, can you see if their DNA is present anywhere?
Well, correct. I mean, I was told to examine the item, see if I could find any stains on the item, and if so, make comparisons to any known individual profiles to see if it matched.
Okay, so as far as Mr. Anderson's jeans, if you could just turn to page 2 of 5 of Exhibit 44 of your report.
Okay.
So under item says cutting of left cuff area of jeans, item AU2, that whole portion.
Okay.
And that was you had talked about it at length on direct with the state, but that was the sample that had resulted in a 2-person mixture, correct?
Correct.
And so you did what's called an STR mix to determine if you could make a conclusion of the mixture.
Correct.
Can you explain what that is to the jury?
So in this situation, I found a mixture that was consistent with 2 individuals. Now, I ran the SDR mix computer program on that sample. And part of the procedure is if you have a profile developed from an item where it's likely that you know one of the contributors, then you need to tell the program that assume that this profile from this individual is present and tell me who the second person is in the profile. So that's basically what this profile did. And then when I compared the known individual profiles to this second contributor, each one of them came back as an exclusion that they could not explain as being the source of that second contributor.
And so one of those mix that you put in for this comparison and analysis was the DNA profile of Mr. Anderson and the DNA profile of Mr. Gutierrez, correct?
Correct.
And when you ran that test, the results came back, the likelihood ratio was 0.
Yes, and that means there's no, it's an exclusion, and the evidence is not explained by a mixture of those 2 individuals. So that person is excluded as being the second contributor.
And exclusion with a 0 likelihood ratio means it's absolutely impossible that none of that person's DNA was on that item.
That's correct.
No further questions for this witness.
No questions on those.
You may sit down, sir. Please don't talk about the case during the break.
Okay, so I know some of that was a little bit heavy. Sometimes I know some of us tune out the DNA testimony. Others of us, that's like, this is the highlight of the case for you. But the reason that testimony was important is because there's only one piece of evidence, of physical evidence, that ties this defendant to the crime scene, and it's through blood, or allegedly blood. Now, I think reasonably we can conclude it was blood based on the appearance, based on how it was, everything that expert just said. There was a tiny bit of blood that, when tested, gave a DNA profile that only would have been able to be retrieved if it were blood or skin, like body material, human material. It's a red stain. It's not a touch DNA cell. I mean, touching something doesn't leave something like that. Basically, you can conclude fairly reasonably that was blood, but defense is going to fight that point because there was a time when the victim in this case actually came to the defendant's house and apparently entered this van. So we're going to hear a story of, they're going to present that of how this occurred and what might have happened that could have caused this drop of blood to appear there. Let's see. DNA, definitely shorter evidence than the OJ trial. Yeah, that was fairly quick DNA evidence. Basically, everything that was tested at the crime scene, all the blood swabs that were taken there, belonged to the victim. The genes that were tested had they were a pair of genes from the defendant, and it had the defendant's DNA and nobody else's, like no combination of the victim and anyone else's. Alex should have hired Goodman Law Firm. Yeah. Let's see. She got the smackdown a little bit. The judge let that information in. I thought towards the end of that objection that she was putting together a pretty good argument, especially as we're talking about the second witness peer-reviewing something or responding to something that wasn't included in the peer review. But apparently they had discussed it individually, and he's able to, with some certainty, answer the questions. Let's see. Has her voice changed in her delivery of asking questions? Jimmy, yesterday we were listening to her on high speed. So yes, it has changed a little bit. Now we're back to live. So it's a little better. Carrie, I'm so glad you found the channel, by the way. It's good to have you here. From Rhode Island. That is awesome. I've got a buddy that found a Rhode Island, I think it was a pine tree shilling is what they call it. It's one of the first coins, if not the first coin, that was minted here in the United States. A very, very rare coin. Found it. I'm not sure if he was in Rhode Island or he was up in the area when he found it, but let's see. We made it through without the jury being sent out. Yeah, that was a whole, we made it from break to break without the jury being kicked out. And the judge hasn't told us directly, but it sounds like there's a possibility that climbing the stairs might be difficult for at least one of the jury members. And there are 21 stairs. We've heard that there is an elevator, which probably is not readily accessible. You probably have to walk a ways to get to the elevator and then go up and then walk a ways to get over to the jury room upstairs. But there is an elevator or a dumbwaiter or something in this building. I'm not sure which it is, but the judge is hesitant to send the jury out because of that, because of the burden it is to send them up to the jury room and back down. So you've either got somebody who's like me, who's got a bad knee, or maybe just climbing stairs physically is a challenge for them. So for that reason, the judge is letting the jury hear a lot of these arguments in the objections that we normally would assume. In the other case, Newman would have sent the jury out weeks ago, and they're still there and they're still arguing and explaining and adding further argument and reasoning behind it. So the jury gets to see a lot more of the trial than probably any other jury would get to see. She did go easy on him, probably because he did such a good job in answering the questions for the state at the end. The way he answered that really didn't leave her a lot of avenues to attack. Let's see. That was a fast DNA expert testimony. It's our second one. The first one has already gone. This was the peer reviewer. So they just wanted to reinforce that one section of her testimony as well. Let's see. Everyone here is friendly. Sometimes people debate, which is not a big deal. That's life, but there's no hate here. You're completely correct, Born a Hawkeye. This is a fun group to be with. Isn't there let's see, Lost Souls Paranormal says, but Recovery Addict, isn't there an accusation that the victim broke into or did something in ZA's van? Yes, there is. And we're going to hear that probably on defense. The state's not going to bring this up, but on the defense side, we will. Bite Me, thank you. You just gifted another membership. And Rock Mike, you're the recipient. Awesome. Thank you, Rock Mike. And Bite Me. Appreciate it. Rock Mike, please type !seat in chat because a membership grants you a front row seat in the court of public opinion. And there's room for you. Everyone will just slide over and give you a spot. Yeah, from a photo, that's even if it was an enlarged photo, I realized that a good crime scene tech can take a very sharp, crisp image of a photo where the area of interest is in precise focus or very close to be precise focus with a high resolution camera, so the image can really be exploded quite a bit and get some more detail that's not visible just to the eye at a regular size. But still, a photo has serious limitations. The light source that's used in the photograph is very important. The angle it's taken at, there's just so many things that really it would be best to analyze that in person. But he said he was able to do it as an expert, and he had enough information. So, and his explanation was fairly solid. Rebel just broke into a 100-count milk bone stash. So now you've got 10, and Rebel is full. Make her walk it off, Ivan. Make her walk it off. 5 more walks today. Let's see. Rhode Island Magic. P-Frog says, I'm an hour behind, having to twist people's arms to go on vacation and take a tour of our resorts promoting timeshare. The steps, the jury is getting plenty of steps. Yes, but if Arthur is your friend, the stairs are brutal, not disabled or limited friendly. Wait till you live to it, Judge. Yeah. The judge is mindful of the jury here. Did we answer everybody's questions? I tried to get all the questions I could, but I also try not to talk over anything that happens in court as it goes down. Let's see. Yeah, Carrie, you'll want to turn on the enable gift memberships on this channel feature. We do have some very, very generous members of the channel that frequently gift memberships, and you want to be in the pool to be able to receive those for sure. You can do that, I think, by clicking the $ button at the bottom of chat, and then clicking from there. You click to, I think there's like membership, something. I can't remember. Now I forget. Sherry Sims Rue, thank you for another month of support. I appreciate that. It looks like that courtroom icon looks great next to you. I'm not sure if I can highlight it, but it lets me move it a little bit. Look at that. Do you see that? Is it moving around a little bit? I can drag it with my mouse. I wish membership gave a different camera view. This particular courtroom, we are limited on the feeds that are offered. I will say membership does not tangibly change how you experience the channel. It's just supporting the channel. It does enable some emojis and some commands that are available just to members. But other than that, it's just it puts your name in green and just indicates that you're supported the channel, which is great. I do that for a couple of reasons. First of all, when I first started, I didn't even want you to have to subscribe to the channel to even talk and chat. I think I wanted it wide open. I think the conversation, whatever it is we're talking about, with the specific trial we're addressing, is better when we have a lot of input. And so for that reason, I didn't want to require people to subscribe. Unfortunately, the trolls are so bad at jumping in and saying stuff. I had to turn on the subscribe thing, and occasionally I have to turn on the slow chat because they'll spam chat. But other than that, I wanted to keep the channel the same as when I started. And I don't want you to have to feel like you have to do a super chat to get a question answered. I don't want you to think you have to be a member to get a question answered. So basically, that's why I operate that way. But I do definitely appreciate all those who do support the channel, whether it be through your own membership or a gifted membership. That is great. Let's see. Adam Nusky says, I like that it's not, that is literally not true for soundbite earlier. Sorry for spamming this. No, I missed all the other ones, Adam, so that's not spam to me. I apologize. Are you able to get a clip of that, Adam, and send it to my burner phone? That would be easiest for me to grab if somebody's able to do that.
There's a lawsuit.
Thank you for answering all the questions. You're spot on. Thank you, Smoke Mountain Lady. I appreciate the questions. Was the small blood tested? Veronica, yes, it was tested, but not tested for blood. It was tested for DNA, and it was tested positive, and it matched the victim. So it was there are two tests they can do. They can do a test that say they look at something and say, hey, that looks like blood. We can do a test with luminol and see if it is blood. If they do that, the area where they test cannot be tested for DNA. Because this area was so small, they said, it looks like blood. We're just going to go straight to the DNA test. And then it came back with a result. They were able to get a DNA profile off of it. But had they tested it to see if it was blood, they would not have been able to test the DNA. So yes, it was tested for DNA instead of blood. And the results were that it was Mr. Gutierrez. So 100% right. Maggie Carr, thanks for catching us up so quickly. I'm glad we're up to date, Maggie. It's so much less stress on me when I'm trying to, jump through all the timelines and have no breaks. But I'm glad we're up to date. So now we can watch things in real time. Thanks for sticking with me through the craziness. Let's see, Kevin. Welcome home, Kevin. Let's see. Admitted being an addict. That is what we call clicking the subscribe button here. Thank you very much. And I do apologize. I realize there are some individuals here who, when they look at the words addiction and recovery, think of something very different than what we were doing right here. And I do not mean to use those words in a way that makes fun of or enlightens that at all. I've been there with family and others. I've been in AA meetings. I'm very familiar with the 12-step process. As I've been a support individual for people. So it's the program itself, Addiction Recovery, is a great program. I'm a big fan of it. I only chose the name because I was addicted to recovering artifacts from the ground. I do have my own gaming addiction that I'm getting over. Heather, welcome as well. I see you there sliding in. Welcome. Thank you very much. India Dausch, welcome to the gallery. I appreciate you becoming a member. Thank you so much. It's good to have you here. We have a lot of new people here today, and I hope you find that all of them are friends. Alex Murdaugh, sound bite incoming. Who is it sending me this one? I do have a burner phone if you need to contact me. Anytime you need the burner phone number, anytime we're live, in chat you can just type !burner. And that will cause the bot, there you go, Eddie did it for me. It will cause the bot to respond, and it will give the phone number that, let's see, here it goes. It's taking a second. The phone number you can reach me at, and that actually does reach me. Some people are so surprised that I give out my number, but I do. I do want to be reachable. If you have something to say, especially something that's hard to communicate in chat, or if you have a concern or something, reach out to me. Let me know, see if we can fix it. Whoa, Pixel Flip just gifted 10 memberships. Let's see where these go. Thank you very much, Pixel Flip. Let's see. Kathy Bauer, Mrs. Winters, Carrie, Wade Lucas, SS, Chris, Mary Beth Robinson, Queen Olive, and Kimosabi, as well as Rick Thomas, were all gifted memberships by Pixel Flip. Thank you so much, Pixel Flip, for your generous donation, and congratulations all of you on your memberships. That is just amazing. Thank you so much. So sweet. Wait, I'm addicted to hunting artifacts. Banjo Jones, I am. I have metal detectors, many metal detectors. And thought I had some artifacts here on my desk, but I don't. I don't know where they went. I do metal detecting, a ton of it. And I love it. It's like dirt fishing. You never know what you're going to find.
Need to keep Scott in pickles so doesn't withdraw. Party face with a party horn. Hat and confetti party face with a party horn. Hat and confetti party face with Scott, a party horn. Your phone, I'm reaching out to you. Confetti face with alert. Tears of joy face with tears of joy face with tears of joy beaming face with smiling eyes. The
emojis go forever. Oh my goodness. Smiling eyes. Two super chats back to back. Let's see. Thank you very much. First was Angie. Need to keep me in pickles. I do. I love pickles. Some of you might know Emily D. Baker, and she has one of these pickles as well. She got hers a day before I got mine. But I like spicy maple bourbon pickles, and that's just been a theme on the channel for quite a while. And thank you for that. And Bite Me as well says, check your phone. I'm reaching out to you. Photo alert. Looking at the burner phone right now. Let's see. Okay. Lots of text coming in. Lots of text. I'm trying to find the right one. This is Alex's response right after being asked if it was a trailer. The file type's not supported for some reason. I can't get that file. Bite me. I think that was you. Oh nope, different one. Okay, I got it. Sleeping all day. It's the cat monitor. I see what you're doing there. Got it. Thank you very much. Watching the cat from work. Toddly Pip says, have you done a poll yet on guilty versus not guilty? I haven't. We like to sort of hold off on that until after the evidence. A lot of us have opinions, clearly, even in the court of public opinion, we discuss things and we develop our own opinions long before the jury goes to deliberation. But I like to keep an open mind as much as possible, just because right now we're only hearing one side of the story. We're hearing a little bit of cross. We're getting a little bit of the angle from the defense side. But I'd like to wait until, defense gets a chance to say, hey, have you considered this? Before we judge that. So usually we wait on the guilt and not guilty till the end, just for that reason. Let's see. I think Judge's chair is being panned by the camera. I'm not sure why. Still no audio from the courtroom yet. Let's see. Let's see. Okay. Did I see your last chat? Was it on the burner phone, Amber? Oh, I've got the koala bears pictures coming in on the burner phone. And I like chicken. I'm getting all sorts of stuff coming in. Okay, Amber.
Norma just sent a super sticker with 4.99.
I wish I could share all the pictures that get shared with me on the burner phone. Some of them I just can't, and that was one. Norma, thank you so much. I'm trying to see what the sign is. Oh, it says number 1 with a fox, by the way. Love the super sticker. Thank you so much, Norma. I appreciate that. Okay. I'm undecided. Need to see all before deciding. This is my first community. Everyone's so kind. No stress. Thank you for letting this lurker chat. We have a lot of lurkers. I know of many lurkers. Like, I personally know the lurkers who say, yeah, I watch your channel. It surprised me because I'm like, you do? I've never seen you in chat. But we have lurkers out there, and that's great. Let's see. Am I a lawyer? No, Brittany, that's a great question. I am not. I could tell you my legal background, but I am not a bar certified lawyer. I've been studying the law since I was in junior high, and using it at that time to get the benefits that I wanted. Namely, at one point, I got all of us let out of class early from school because of the law and because I knew the law. And so I've studied it. I'm the kid that instead of watching TV after school, I'd go home and I would read the proposed bills in the legislature. And just, so I've got a lot of experience that way. I love studying the law. I love studying the impact of the law on us and just learning the quirky things about it. And I like true crime. So that's where the two came together. Now, we do have, for those times where we have a necessity to have legal analysis, we have people like Matthew Harris and Nicole at Goodman Law Firm. We have some great friends of the channel who are lawyers, who are practicing lawyers, who will come on. Occasionally they'll come on video or just over the phone and give some analysis and feedback on what we're learning and watching and why it's happening or what should happen. It's extremely useful, and they're great friends of the program. Carol Connolly.
Carol Connolly just sent a super sticker with 4.99.
It's got the hippos. We've got 3 hippos. Thank you very much, Carol. Appreciate the super sticker. Bone Digger says, I'd love to metal detect ever magnet fish. I love the idea of magnet fishing. I've used someone else's, but I've never had one myself. I've got a good friend actually not far from me, just a few miles away, that has found several old firearms, like really old firearms, metal detecting in a river. I am in an area that has a lot of Civil War history, And so that idea is just fascinating to me. But here's the problem. If I'm magnet fishing, I can't metal detect, right? The two usually don't go together. And usually if I have time, I'm out metal detecting. I did just get sent a new metal detector from a company that wants me to test it. And out of all the companies that sent me metal detectors, this one is actually good. I've never had a good one sent to me. They've always been just junk, cheap ones that I wouldn't recommend. And now I've got this one that's good. And the first one they sent me was bad. I said, hey, here are the problems with it. I listed it. And they went back to their the drawing board, and they fixed the problems, and they sent me the new prototype. It hasn't even been released yet. And they said, okay, we've addressed all the issues you said. Try it again. And they fixed it. It's like, you've got a good machine here. So I'm excited. I think they're going to send me one more that will have the actual branding and stuff on it. We're waiting for the audio here. Judge is talking. It seems animated. Let's see. Is Ivan back yet? I think he was out walking his dog. I'm not sure. The dog's still.
Court is now in session.
That was perfect timing. Whoever triggered that sound effect from Judge Newman's court. Let's see.
Bring the jury.
Bring the jury. The state seal does sort of look like a turnip or an onion on the top, not a badger. Awesome. Stephanie Willis, thank you for subscribing to Ivan's channel. Ivan's a good friend of the channel here. Something's up with the defense table. Check out their folders on their table. That's just impressive. They've got all their trial folders.
Are you folks comfortable?
I am.
Now that you've been here 8 days, I should ask if they're comfortable.
How are the chairs?
Please raise your right hand. Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you.
Let's hear the name of this witness. I'm not sure who it is.
Remsburg, can you state your first and your last name, and please spell both your names for the record?
Catalina Remsburg, CASALYNAREMSBURG.
Wow.
I want to turn your attention back to the time period of mid-May of 2020. Were you employed in May of 2020?
Yes.
And in general, what kind of job were you working?
I was an assistant kitchen manager at Quick Trip.
Okay. And were you living with anyone during that period of time, May of 2020?
My older sister, Christine.
Okay. And is her last name Remsburg as well?
Yes.
Okay. And how long had you been living with Christine Remsburg by the time period of May of 2020?
About 2 years at that time.
And in that capacity of knowing Christine Remsburg, is there anyone here in the courtroom you also came to know through her?
Zach.
Okay. Is that person that you've just named as Zach here in the courtroom?
Yes.
For purposes of the record, could you point out where that person is located and say what they're wearing today?
He's right there. He's wearing a gray tuxedo.
Indicating the accused.
Okay.
What did he say? I love you? Or that's
so I'm
true?
going to refer to him as the defendant.
Okay.
Tuxedo?
You'll know who I mean, correct?
Yes.
Okay. So, Ms. Remsburg, during the time period that you were living with, in May of 2020, how did you know the defendant? So, like, how was he connected to either you or your sister?
He was my sister's boyfriend.
And how long had they been boyfriend and girlfriend to your knowledge?
About a year.
Okay. And that was all a period of time that you also lived with your sister?
Yes.
And during that approximately a year, how many nights, if ever, would you estimate the defendant would spend at your home with Christine Remsburg?
About 4 or 5 nights a week.
And that was through that entire about a year?
Yes, about.
How often did Christine Remsburg go over to the defendant's home during that time period?
She almost never, only once.
Once in their entire relationship?
Yes, that I know of.
Okay. And at the period of time of May of 2020, now I'm directing you now to May 17th through 19th of 2020, right? Just before someone came and found you at Quick Trip.
Okay.
Did you know your sister to be driving a particular vehicle during that time?
Sometimes she would drive Zach's car, which is the black Audi.
Okay. And why was she driving that car, if you know?
She wrecked her old car.
When she wrecked her car, was she, to your knowledge, was she the regular driver of the Audi because her car was wrecked?
Yes, I think so.
Okay. And so what car did you observe the defendant driving during that period of time, so May of 2020?
He usually drove the gray van.
That would be the most common car you would see with him?
Yes.
And now I'm going to turn your attention to May 19th, 2020. Did you work a 2 to 10 shift on that particular evening, if you recall?
Yes.
And on the 19th of May of 2020, did some people come who interrupted your work shift?
Yes, it was 2 detectives.
Okay, and did they appear to be from the Kenosha Police Department? If
yes.
you know?
Yes, I think so.
Okay, and were they asking you about what had occurred 2 nights earlier on May 17th, 2020?
They asked me if Zach was at the apartment that night, and I said no, he was not.
And you felt confident of that?
Yes.
Now, it had only been 2 nights earlier, right?
Yeah.
So your memory wasn't a problem?
Yeah, correct.
Okay. And do you know on that was a Sunday, so on that Sunday, May 17th, 2020, did you work a shift?
Yes.
So you worked from when to when, if you know?
I worked 2 to 10 that night.
Okay. And then where'd you go next?
I just went home right away.
All right. And when you got home, what, if anything, can you say about whether the defendant was present?
He was not.
And was anyone present?
My sister was.
And what do you recall about how your sister was acting or feeling about the fact that the defendant was not present?
She was a little upset because she was going to make dinner and he wasn't there. So.
All right. And at the time you saw her after 10, did she have any explanation for why the defendant was not present?
Objection calls for hearsay.
It does.
Is it being offered to prove the truth of the matter asserted?
Yes.
Yes. So it's hearsay.
She's already testified. Ms. Remsburg has already testified. This is her simply indicating what her impression was.
Yeah.
Let's keep it with
Objections overruled.
Okay. So again, did it appear to you that she knew, had she received any information or knowledge of why he wasn't there?
No, I don't think so.
Okay. What time did you go to bed that night?
Probably around midnight.
Ivan, we're going to get you to 200
Other than
subs
you
today,
and Christine
for sure.
Remsburg and then the defendant 4 or 5 nights a week, was anyone else living in the residence at that time?
No.
He does a lot of leading, and there's not as many objections as there should be. Ivan, you're going to have to explain why everyone calls it an Audi instead of an Audi. It seems to be like only about 50% of the people that do it, and some of them call it both ways.
If you know, during this time period of May of 2020, were there times when your sister and the defendant would leave and go elsewhere, go out someplace together?
Once in a blue moon, they would.
Okay.
Yeah.
And if you recall, what vehicle would they commonly use? Again, if they used one vehicle commonly, if they both went out somewhere.
I think it was a black Audi.
Okay. I don't have anything else.
The state had asked you about, when your sister and Mr. Anderson were dating, if they would go out on dates, and you said maybe once in a while. Remember that question?
Yes.
It's true that the majority of the time that they'd be hanging out, they'd be in the house watching movies, things of that sort.
Yes.
No further questions.
Nothing on that.
You may step down.
Okay, that was a quick witness. No.
State calls Marquand Washington to the stand.
Marquand Washington.
Yep.
Blue moon occurs every 2 to 3 years. So that's how often they would go out. Yeah, I hear you on the audio. That makes sense. Audio and Audi.
Do you solemnly swear the testimony you're about to give in this matter will be the truth, the whole truth,
Sir,
and nothing but the
sir,
truth?
do you have any prior convictions?
Please be seated.
That's going to be the first question.
Mr. Washington, can you state your first and your last name and spell your names for the record?
Marquand Washington, Marquan, Washington, Washington.
This is going to be
How
some
old are
good
you
testimony.
today?
31.
And where have you most regularly resided in your life, lived in your life?
Racine, Wisconsin.
Okay. Have you ever been convicted of a crime?
Yes.
How many times?
6.
And are you in custody right now for charges that are called federal charges?
Yes, sir.
And does that mean the U.S. government is prosecuting you?
Yes, sir.
So it's not the state of Wisconsin that's doing it?
No, sir.
And pursuant to that federal charge, in general, where are you being housed? Are you in a federal jail or prison, or are you in a state institution?
I'm in a state institution in KCDC, but it's mixed with federal as well.
Okay. And so KCDC is a institution or jail here in Kenosha?
Yes, sir.
There's a bailiff just off screen.
Judge, could you ask the witness to talk right into the microphone? Can barely hear him.
Yeah. You got to speak up. Okay. Can you do that?
Yes, sir.
Yeah. Thank you, counsel. So, as part of your federal prosecution, is a institution or jail here in Kenosha?
Yes, sir.
Judge, could you ask the witness to talk right into the microphone? Can barely hear him.
Yeah. You got to speak up. Okay. Can you do that?
Yes, sir.
Yeah. Thank you, counsel. So, as part of your federal prosecution, have you entered into a plea agreement?
Yes, sir.
Okay. So I first want to talk about what your federal charge is. What do you understand you are charged with right now?
Conspiracy.
Okay. And is that to conspiracy to deliver drugs, illegal drugs?
Yes, sir.
And what are the drugs that you are charged with conspiracy to deliver?
Cocaine and marijuana.
And would it be accurate to say that the cocaine that you are charged with conspiracy to deliver is 30 plus kilos of cocaine?
Yes, sir.
Okay. And what quantity of marijuana are they saying that you were in a conspiracy to deliver?
I believe 600 pounds.
Okay.
Oh.
And
just a
and
personal
so you've
consumption
entered
amount.
a plea in that case. Is it a plea of guilty?
Not guilty yet, but.
Okay. So what is your status right now in that case?
Witness's last word was but.
I thought he said not guilty yet.
Correct.
Oh, I thought
He said yet.
I thought you said yet. You're right. That mic doesn't work for it.
Yeah. Okay. Should I go on?
Yeah, please.
Okay.
Sorry to interrupt.
So, and is it your plan to enter a plea on those charges?
Yes, sir.
Okay. And have you entered into a plea agreement with the government?
Yes, sir.
And is that a document or agreement you've signed?
Yes, sir.
And does it indicate you are going to plead guilty to some charges?
Yes, sir.
So did you do these offenses that they're charging you with then?
Not the amount, but yes, sir, I have.
Okay. So you're pleading guilty to the charges that we're talking about?
Yes, sir.
All right. Does the plea agreement, what does the plea agreement say about whether, if you know anything about other crimes, whether you should talk about it or testify or any of that? What do you understand your plea agreement to say about that kind of stuff?
The plea agreement basically, it said that if I was to enter into this plea agreement and sign it, I would have to be honest about anything that I had knowledge about.
Thank you, May. Appreciate the super sticker.
So you're obligated. You're supposed to be obligated to do that.
Yes, sir.
Okay. And is there a benefit that you believe you would receive if you provide information on different cases?
If I'm honest about everything, possibly yes.
So
he stands to benefit by testifying.
What do you understand could be your advantage? So like how could you be helped if you're honest about some other crimes?
What do you mean, like?
Well, like what advantage do you, what's in it for you, I guess is what I'm saying.
Well, leniency on sentencing, I guess so.
And do you know what that means? Like what number that means?
No.
Okay. Has anybody told you what the number is?
No.
And what is your understanding of what happens to you and your agreement if you are dishonest to a court or to authorities? What happens to you if you're dishonest?
I probably wouldn't get anything for it.
Okay. Are they able to hold that against you?
Yes.
So could you be worse off if you lied?
Probably so, yes.
Okay.
600 pounds of marijuana.
Could you mess up your whole agreement?
Charge.
Yes, sir.
So, and have you been warned about that? Have people told you, here's what might happen if you make something up or if you lie?
Yes, sir.
So you feel like you understand what the consequences are if you were to tell lies in a courtroom or to authorities about any matter? You think you understand what happens?
Yes, sir.
So how long have you been in a jail in Kenosha on these federal charges? Like when did you first get to Kenosha for jail on the federal charges?
I believe about 15 months ago.
You remember what month it was or not?
December, I think, of 2021.
Okay. So, and at some point during your time in the Kenosha jail system, did you come to be housed with a person who you found to be named Zachariah Anderson?
Yes, sir.
And what did you call that person? Like when you were speaking to them, what did you call them?
I called him Zach.
Zach. Were you, if you know, did you room with that individual personally? Like you were actually a roommate of that person's?
Yes, sir.
And which institution? So there's a downtown jail and then there's KCDC, right?
Yes, sir.
Have you been in both of them during this period of time of incarceration or just one?
I started off at downtown area for a week or so, and then I went to KCDC.
Okay. So is the place that you roomed with this person that you said is named Zachariah Anderson, was that downtown or was that out at KCDC?
It was at KCDC.
And when I say that you room with someone at KCDC, tell me what physically that means. Are there 5 or 10 roommates, or just, how many people are, when you say you room with somebody, how many people does that mean?
Just 2 people, me and another person, which was Zach.
Okay. So for a period of time, it was just you and Zach?
Correct.
Okay. And is the person you're identifying as Zach, is that person here in the courtroom today?
Yes, sir.
So could you point that person out today, and Mr. Washington, tell me what that person is wearing today?
Yes, sir.
Please point that person out.
Yes, sir. He is right there in the gray suit with the gray and blue tie.
I'd ask the record to reflect identification of the defendant, Zachariah Anderson.
Pointing at the defendant.
Mr. Washington, did you room with the defendant for a time period from about December 22nd, 2021 through January 31st, 2022? Does that sound correct?
Yes, sir.
So if I calculate correctly, that's approximately 5 weeks, right?
Yes, sir.
Okay. And during that time, did you and the defendant come to know each other?
Yes, sir.
And did you have discussions with the defendant during that period of time?
Yes, sir, we did.
And at some point, did you discuss your case?
Yes, sir, I did.
And at some point, eventually, did the defendant discuss his case?
Yes, sir.
So when you discussed your case, who else was around when you were talking about the details of your case with the defendant?
Just me and Zach.
When the defendant discussed his case, was who, if anyone, was around other than you and the defendant?
Just me and Zach.
What, if anything, can you say about during the period of time you were with the defendant, whether you observed any behavior about him having trust issues about people or being paranoid or worried about the government?
He had a lot of paranoia and different trust issues when we was in the cell.
Okay, you got to speak very clearly, okay?
Okay.
So, all right, so what sort of things did you see that caused you to think, okay, this guy is thinking the government is doing stuff?
Oh, when I was in the cell, he would, initially stated that it was a couple of times that he thought maybe that the government was putting informants in the cell with him, or maybe bugging the cell or recording things without his knowledge.
And did you ever see him do any searches?
Yes.
And what did he tell you, or what did he indicate to you he was searching for?
He was checking to see if there was any recording devices around or some type of camera or something in the vent, just looking.
And did he ever discover anything?
No.
And what, if anything, can you say about whether the defendant, what his opinion was of his own intelligence or about an ability to be outsmart people?
Well, he thought he was pretty much smarter than everybody, pretty much.
And what sort of thing did you hear that caused you to believe that?
Just the things that he said about, like, eventually when he talked about his case or how he would deny things but thought that he was going to beat the case, actually, and that you guys were trying to frame him and he was going to get out.
Who did he say was framing him? Do you remember?
He said the police framed him.
Did he say how they had framed him, what they had done?
No, he just said that they was planting evidence and trying to put something on him that he didn't do.
All right, so he indicated to you specifically that the police had planted evidence?
Correct.
Was that said to you once or more than once?
Said a few times.
Okay. And can you indicate any ways that you and he helped each other out? In other words, anything that caused you and him to begin to trust each other for any reason?
Well, when I was in the cell, like I said, we became close. Sometimes, like, if I needed him, he would come through for me, and if he needed me, I would come through for him.
And give me an example of the kind of ways you mean.
Like the first time ever was because he usually don't share or do nothing or order much. He holds on to the stuff that he have. He had some food that I needed to cook with at the time, which was tuna. And I asked him, could I get the tuna? And I would order him, 4 back for the tuna, because he did it before with other people, and some people didn't come through on the end. And I showed him that I come through.
So, Your Honor, Mr. Washington is sort
seems
of
like a little
soft-spoken
thing,
and the words
but,
come out kind of quickly. Can we just ask the jury, can they understand him so far? I just want to be sure that they're able to understand him.
Little things like that can be signs of loyalty.
So, Mr. Washington, it sounds like you negotiated a loan kind of thing, right? You pay me now or I'll pay you later kind of a deal.
Sure.
Okay. Was there a point where, in discussing the defendant's case, that he talked about any involvement of his brothers?
Yes. He said that he couldn't have contact with his brothers because you guys basically try to say that they had something to do with whatever he had going on with his case, but he didn't.
And did he indicate to you, did his brothers have anything to do with any of this?
He said they didn't.
Okay. So how was he acting about that? Was he sad? Was he very calm about that? What was his reaction to the idea that
Judge,
hold on, let me finish. That his brothers would be involved?
Judge, objection leading, and he's been doing it repeatedly. I let it go, but definitely leading.
So I've directed him to a topic, and then I've asked what, if anything, was said about that. That's not leading.
And then gave 4 options.
Well,
and if I
no. I think it could be less leading.
Okay, so what, if any, reaction did the defendant have to the issue of his brothers being suggested as being involved in this incident?
Well, he was angry about it. He was mad, actually pissed off. I don't know if I could say that,
Okay.
But you did.
And were you able to find out some personal details about the defendant's background?
Yes, I was.
Okay. So what, if anything, did you come to know about his family in terms of who he got along with, those kind of things?
I found out that, he had brothers. He had supposedly have a sister or something. I don't recall a sister. I don't know if it's a sister or not. Him and his dad wasn't close growing up. He lived with him or something like that, but they didn't have a always good relationship. He told me that they fought one time. He was tough on him and his brothers, stuff like that.
Did he say anything about anyone dying?
He mentioned something about somebody passing away, but I don't remember who it was.
And did he indicate whether that was a problem for him with his own family?
Not that I can recall. I just know that he said he was split up. He wasn't with his mom or his dad. I don't know how he got split up or what was the reason why he was split up.
Did he tell you in terms of sort of everyday jobs, not doing illegal stuff, but as terms of everyday jobs, what sort of professions he had worked in?
Yes, he told me that he was in did cabling and construction work like that.
Okay, the first one was cableman.
Yeah.
Okay, and the other was construction.
Correct.
And then, did you have any topics that you felt like the two of you bonded over? You had some things in common.
Yes.
And what was that?
Illegal things.
Okay, so what?
Objection. I think we've revisited this before. I think I'd have to be heard outside the presence of the jury here.
Your Honor.
What would the relevance of this particular answer be?
Okay, do you want me to... I would reveal a lot of details by saying it. I will if the court wants me to, but I want to be careful.
It's that time again.
It's that time, jury. Head to the library.
Shouldn't be long. Let's not talk about the case.
We've already lost an alternate. I'm not sure why the cameraman is just like all over the place. Apparently very interested in the pictures on the walls. What they're going to be getting into is that Zachariah was involved in the marijuana trade. He grew 70 or so plants or something. I think inside is what I heard. I'm not sure where. If you saw the pictures of his house, there wasn't much room in there for anything.
All right.
So,
the objection was...
So the objection, Judge, was that, and I was concerned about this as I read the reports, not only from the interview that Mr. Washington had with Mr. Gravely, but from the debriefs, that that there was some discussion supposedly between the two, Mr. Anderson and Mr. Washington, about what the very things that we were worried about before, accusations of drug dealing, the other case he has. And so when he asked about other regular jobs, I thought, okay, we're going to avoid that. I thought we were going to avoid it. But then the very next question was, his answer was about what else did you discuss about, I don't know if it was about work or whatever, but it was, and I think he just said illegal things.
He said, what do you have
about
in common?
What they bonded over. And so clearly that's where it's going, or, maybe we can nip it in the bud here, but that's the reports from his interviews, in at least a portion of it involve talking about Zach's other case and, going back and forth from California, that sort of thing.
Mr. Gravely.
Yeah, so I do intend to bring these details up. So this is not something that I'm doing accidentally. So Mr. Washington has indicated in his debriefing to us in our discussions with him, and this is revealed in the reports, that the reason these two bonded, the reason that they felt they could confide in each other, was their shared discussions about the drug business that they had been involved in. So, you know, just like you might say as an inmate in the jail, I bonded over fishing, or as an inmate in the jail, I bonded because we went to the same high school. This is how these individuals bonded. I mean, this is the true facts that was described. And some of the details that Marquand Washington knows are things that are not in a criminal complaint. There are details which reveal that Marquand Washington had real conversations with the defendant. Not that he is just an individual who could come in here and be a mercenary and just describe some facts that he read in a newspaper article. And I just want to give you a couple examples of that. He said he caught a case going back and forth from California. But he's not worried because it's not that much. He's right. In the context of these sorts of cases, it's not as much marijuana as many cases are. And it is a case where he's caught.
Zach has a case where he's charged with having 10 pounds of marijuana.
West Coast. So again, this is something Marquand Washington knows that he wouldn't know through any other source. The next one is that the police in this case raided his house, took a bunch of money from him, but just a little bit of weed. Again, in the context of these gentlemen, this is 2 pounds of weed, which is not a lot of weed in the context of what you've heard, but it is more than $47,000. So it's a lot of money. And so again, this is something that Marquand Washington knows because they've had common discussions about the drug trade and what they have each done within the drug trade. The jury has no other reason to presuppose that Marquand Washington would bond with the defendant. They have no other logical connection. They did not grow up in the same city, et cetera, et cetera. And this is the actual answer offered by Marquand Washington when he was asked the question, how did you guys come to bond? He said, we bonded over our discussions of our various activities in the drug trade. And that is the answer he offered as to why he knows those kind of details. So again, Judge, this is, the jury has already heard and been permitted to hear that he was on bond on a matter in South Dakota. They've already been permitted to hear that there was a grow operation that had gone on at his home. So there are facts already in evidence in this case. This is not information that will be a shock to the jury or is that, but it has a very specific purpose to let them know Marquand Washington has some reason to know or have some reason to have these details at his disposal.
Judge, this is a pretty not very transparent attempt to backdoor some other acts. There was no motion about this, and just because they do a debrief with some informant that they want to call as a witness doesn't mean it's all admissible. Just because that's how they bonded, that doesn't make it admissible. That doesn't make it anything other than what it is, which is an other act, which requires a motion before the court and a ruling by the court. And none of that was done.
Judge is thinking.
All of this stuff was widely available in the media. It's on the complaints. It's all public information. So, the fact that, even besides the fact that they need to fit it into another acts analysis, it's and it's not relevant. It's still not something that goes to prove what they're purporting it to prove, which was the bonding.
I want to indicate again that counsel's made an argument that this information is in the criminal complaint. I don't think there's any mention of the money in the criminal complaint or that marijuana was recovered in the complaint. Do you agree?
I'm working through all the
Yeah,
pages, but
and I'm not aware that the complaint has any details about the defendant's involvement in the drug trade. The only thing it says is that there is a conviction in South Dakota because, of course, it alleges him to be a repeater.
I said the news media and the complaints.
Again, I'm not aware of any specific coverage, and maybe you guys are aware of it, and I don't know it, but I'm not aware of any specific coverage about his drug activities that have occurred in the media.
Yeah, and I was referring to the Zachariah County complaint also.
Okay.
It sounds to me like evidence which is generally inadmissible. Other crimes, wrongs, and acts.
I missed the last part. Apologize.
Other crimes, wrongs,
voice,
and acts.
We lost your voice.
Everyone should be so lucky. It sounds to me like you want me to let in evidence which is typically barred by the rules.
Judge has a word
because of the risk of the defendant being branded as generally a criminal personality or having a character trait of criminality. And in order to bolster the testimony that he committed a crime in this case, which is dissimilar entirely from the bolstering evidence.
This is his cellmate.
I have to say,
who was sort of snitching on him.
I understand the logic
sort of
of
like in
your
a big
position.
way.
What I don't recall is any time this has ever been permitted, nor any time that I've read in a decision or a treatise that this would be a permitted use. Now, I understand those have swollen a great deal in the last 50 years, the usage of these types of materials, but the general rule is still one of exclusion.
This witness is going to testify about trackers and how to track people.
There's a warrant done in this case, which is part of this case. So it's not another act. There's a warrant done, right? Found in the warrant is 2 pounds of marijuana. Okay,
thought it was
substantial
10.
amount of marijuana for any kind of, for
so 2 is not very
any
much.
kind of typical drug investigation. There are a number of items that certainly anybody involved in this case would identify as marijuana seeds. The daughter of the defendant provides information that while she is staying at the house, which are on visits, that the defendant is involved in the cultivating and manufacturing of, and she actually knows the specific number. She can say of 72 plants.
Ivan, we'll hear from you here
more
soon.
about the cultivation
as soon as there's a break.
and production of marijuana as an interviewed 12-year-old than I do.
But you'll have to cool off. No bad words, no cursey words.
Goes through detail about that in her discussion with law enforcement about her father, the defendant, and his conduct. The defendant, we've already said in this case, the defendant is on bond in South Dakota on an offense. So the jury already knows there's a warrant, drugs are found, they know that there's bags of material out there that were the soil from a marijuana grow. They know that they've heard already that there was a marijuana grow that had taken place at this residence. So these are facts that are already in the jury's sphere. And frankly, Judge, we're in a situation now where persons who are in the marijuana business often are doing that legally in many places. And so I can't remember what the vote was in Kenosha County for legalization, but it was significant. I want to say it was 60% plus in Kenosha County. And so I don't think we live in a world now where I have no evidence, by the way, so I'm not aware of any time that Marquand Washington would indicate that anything other than marijuana was involved in the defendant's dealing. So we're not talking about a guy who Marquand Washington will say was dealing fentanyl or was dealing even cocaine. So they're talking about quantity marijuana business, which is the way that these two first had their substantive discussions about, about what they have been up to in life.
I don't think it's pertinent. You've already said they bonded over tuna fish.
Judge. You don't get to, you don't go right away to, hey, have you committed a murder? You have some discussions about what each of you have done to get you. That's the icebreaker. And frankly, marijuana is not held in such disdain now, or with such acrimony that I think that there's any realistic feeling that there's prejudicial effect for the defendant. I'm not ever going to argue, and I don't think anybody would ever argue, because the defendant has marijuana involvement, therefore he murdered. And this was a discussion we had earlier, Judge, on a different day, where the court asked me, are you, and the defense, are you saying that there's a connection here of the marijuana business to this offense? And we have said no. What we've said is that they opened the door by showing some bags and asking, cops, why didn't you search this? And those kind of things. But in this case, we're not talking about doors being open, but we are talking about evidence that they already have, that the jury has already heard. This is just supplemental evidence to this, and it is the direct, honest, real, and truthful answer that it's the icebreaker.
Don't use the word honest.
I apologize.
That's not for me to decide.
Okay. It is and so I shouldn't use truthful either. It is the offered answer by Marquand Washington about why we were able to have any discussions about things.
But the problem is we have to realize that the rules generally exclude this propensity evidence. It is clearly barred in order to prove that the defendant has got a character trait or
totally agree.
Propensity to commit any crime.
Totally agree.
And there are a number of exceptions. If you go to the textbooks, Professor McCormick said it has to, for admission, it has to bear the signature of the accused in identity cases. It has to be the type of crime that is actually his signature. We all watched Home Alone at Christmas time again, and that I don't remember their names, but the
I did not.
Guy was not so smart. Always wants to leave the water running. It's his signature at the crime scene. And that's what McCormick talked about.
Home Alone was just cited for case law, I think. That's what I heard.
But it has utility. And the black and white rabbit case, the Woody case, that is beautiful example. This deviant approaches children on different occasions and says, help me find this black and white rabbit. And that's how he gets contact with the children. It's his signature. We're not using it for that purpose here. What you're asking me is to admit this, and I'm not saying you're illogical, but you admit it to show the trust that these two have with one another, that they've bonded. So the criminality that they're discussing, the witness more believable.
So the court agrees it's relevant because bonding would be relevant.
If I could be heard, because I...
Well, yeah, all right.
Yeah, thank you. So there was a limited inquiry earlier over objection, but now what's clear is not only are you correct, this is another act, as we've discussed, clearly barred. But now it's also clear that this isn't some supplemental, to use the state's term, this isn't some supplemental offering. This is like turning into the main aspect of their case. And he keeps talking about how there's all this marijuana at the house. Well, we don't know that. None of it's been tested. And it's a separate case.
But I do agree with his observation that people are feel very differently about marijuana, whether it is or isn't. The governor has proposed to make it legal. I was just reading the budget portion yesterday. It's supposedly legal in the state of Illinois. The president has proposed that it be legal. And public attitudes have very clearly changed so that what was once viewed as a very, very serious matter is not looked upon that way. Even people who oppose its legalization will get on TV and joke about it and about their own experiences with it. And so it's not what it once was.
And I think that's true, but that still doesn't get us past Sullivan or Witte or any other, or the statute itself in terms of its admissibility. So I think the court is on point with the fact that this is, in essence, it's, no matter how the state wants to couch it, it's still character evidence, and it's still there for, they're trying to get it in sideways for an improper purpose, and it needs to be excluded. And they need to be on notice that they can't do this with Sadie, and they can't do this with his daughter, because they're full, as he just said, they fully intend to do that.
Yeah, we do intend to do it through Olivia. I don't think Sadie has anything to do with this, but Olivia is going to indicate that all of these things occur, and if Olivia is lying about her father's activities in terms of all the rest of this, how odd that she would be telling the truth about the marijuana that was grown there, that evidence was discovered of. That's not a distinct another act. That is conduct going on when this case occurs. If we were in the same county, Judge, it would be in the same complaint. It's just that it happens to be in it happens to be in a different county, that it's not in the complaint. So that's not a distinct behavior that's different, and it's simply something that can't be charged here because we don't have venue on that. And in fact, it is a charged case, I guess, in Ozaukee County, right? But I don't think it is any distinct other act, Judge. It is these two indicating, here's how I do it, here's how I do it. We're not saying, and then he told me in January of 21 he did this, and then he told me of this. So it's not distinct sort of specific acts or specific items.
Why not? They're acts.
Well,
it's talking about.
It's generic. It's how I do it. It's how I do it. Kind of. That's the sort of information.
But there are other crimes, wrongs, and acts. I mean, it's even if it weren't a crime, it would be an act. It's character evidence, and the general rule is exclusion, except for specific aspects which are admissible for legitimate purposes. And what's getting me, and this is what I was trying to get at before, in all of the encounters I've had with this type of evidence, which is frequent, I've had it argued it's proof of motive, it's proof of identity, it's proof of modus operandi, it's proof of this, that, and the other thing. It's proof. It even became, after many years of judicial resistance, it's become proof of veracity. Now you're offering it to me as proof that this is a believable witness, that he was bragging about his criminal behavior with the defendant who was bragging about his.
It does. It is used for the purpose of bolstering the credibility of this reporting witness, which is one of the purposes Witte is permitted for. To bolster credibility.
It bolsters his credibility.
To bolster the credibility of a reporting witness. Yes. So, for instance, in sexual assault cases, Judge, you're allowed to bolster the credibility of a reporting witness. So, I guess what I'm going to ask the court to do is let me, as I did last night, try to dazzle you with a case which the court will strongly consider in the morning. So I will do the research, and I'll try to bring the court, because there's a body of law under Witte, under 90404, which allows for a valid purpose of other acts evidence to bolster the credibility of a reporting witness.
So
I'd
Judge,
like to be able to do that.
so he's now pivoting very quickly under your fire that now it's not just the bonding. Now it's part of Witte. Now it's part of Sullivan. Now it's proper under the other acts, even though it's not an other act. So he's trying to, I guess, run parallel paths here. But the bottom line is that if he was, okay, we all know it's another act. And that requires a pretrial motion, not something on the fly during trial. And even if we just ignore his comments about how it's not another act, he doesn't get to just come up with a case and try and argue it. And this is not some incidental thing to his case. He's made it clear. He wants to do it through Mr. Washington. He wants to do it through Olivia. He's already done it to a lesser extent in prior witnesses. So he wants to turn this into a drug case and to smear Mr. Anderson's character. Pure and simple, and that is precisely what 90404 is about, and to prevent.
So, Judge, counsel, has indicated I think has indicated there's something untoward for me to make an argument about what I believe that the presentation of the evidence is, and then in response to the court, when the court suggests comments from the bench, you're the guy wearing the robe, and you say things like, well, I consider other acts, etc. It feels like it's not dishonest for the prosecution to then say, well then, Judge, I'd like to be able to present you a Witte case because there's body of law. I don't think it's a dishonest change of argument to listen closely to what the court says, to understand what the basic parameters and guidelines are of the court's current thinking, and to try to respond to that. I wonder why we would need to have the quality of our debate here be that those kind of things appear to be dishonest. I've cited nothing that's wrong.
I don't want to get into
Sure.
these attributions
Okay.
about. It's pretty clear that you people have not been on the same track with respect to how to handle the case, and I don't care.
Right.
But what is this case that's going to dazzle me? What's it going to tell me?
Don't turn off the mics now. We want to hear this.
While they're looking, that's the reason we have pretrial motions, so we can rationally do research, present it to the court, have a hearing, and not something where we're just changing our theory mid-sentence and then try and find a case quick.
So the counsel said that this case was all about the drug evidence, and of course this case is all about the DNA evidence. So Judge, we suggest to the court that I believe I'm aware that there are cases as I have purported. I don't need to repeat it. There is also a possibility that what's called panorama evidence, in other words, setting the circumstances. Again, I've already outlined why I think this meets the credibility, would also be a valid, Witte place. So, again, Judge, I'd like an opportunity to convince you by showing you a case or two that puts us in that position before we go any farther and not have this allowed. I think it's important evidence in this respect. I don't know why a jury would believe guys who spent 5 weeks together have bonded enough for a murder to be confessed to them unless there's something that is a middle ground. I don't need to repeat that again in any detail. I think the court has heard me and understands that there's relevance in that respect.
Shelley,
and
welcome
so now
to the gallery.
I just want to see
Thanks
if
for
I can
becoming a
find
member.
a case now that I understand that the court feels it's other acts, which was not my first thought process.
Well, there was a scheduling order in this case to file these motions. Enough said, right?
Well,
And for what it's worth, I've litigated other acts motions for decades, and I'm very positive that the first prong of the proper purpose has never, ever, ever included bolstering a witness. Ever.
I think the judge is going to side with the defense here.
oh, I think it's admissible since maybe the early 90s. It's admissible for veracity, to bolster veracity.
Yeah.
Well,
I mean, counsel's indication that he doesn't believe any of these cases exist is exactly why we should talk about this, because his argument is being made indicating he doesn't think there's a body of case law about this. I believe there is, and the court has just, I think, confirmed that. So,
well, no, that didn't say that at all. What I said was that that this should have been brought pre-trial. It's clearly a huge part of his case, and he's trying to turn a murder case into a drug case. But he's actually trying to win a murder case by turning it, like by smearing it with the veneer of a drug case.
He would be trying to win a murder case with
that much
financial
is clear.
cases.
He's not trying to bolster this witness's testimony. He's
absurd.
trying to smear Mr. Anderson's reputation.
These arguments with this rhetoric, Judge, should be admonished by the court.
We're busy right now.
Candyland chat, what is it called? Candy Crush? Is that what he's doing? Give him a minute. Let him finish this level, and then he'll answer. My birthday is later this month. Actually, those who are asking. I believe that makes me an Aries. Mine's after Ivan's. Judge is now surfing the web. I think he's looking for Airbnbs. He's trying to get away, book a vacation.
Well,
I stopped aging it.
For which, and I do think it's other evidence.
I stopped aging
Otherwise,
at 21.
it would be irrelevant.
But that was more than 21 years ago.
Motive, opportunity, intent, preparation, or plan. Well, these are the ones that are both in the statute and then in Instruction 275, which is suggestive of other uses. Knowledge, identity, absence of mistake or accident, context or background. And then it says identify other issue. So there are, as we know, there are other issues. And then there was case law, I think, in the late 80s, early 90s, that recognized it could be used to bolster the witness's credibility. But I didn't think that the language of any case was sweeping enough to extend to allowing witness to testify as to braggadocio that he and the defendant exchanged to prove the accuracy of unlawful behavior of the defendant, for which he's not on trial. It's not to be considered to conclude that the defendant has a certain character or a certain character trait trait and that he acted in conformity with that trait or character with respect to the offense charged. So that's...
Delivery of marijuana does not equal murder. I mean, no,
correctuendo.
So I'm not asserting it for the purpose of indicating it makes it more likely he committed.
So it becomes relevant because during the course of the discussions, the defendant made some admissions, you claim, with respect to the crime in chief in this case.
Indeed.
And you could introduce those stripped of the other crimes, wrongs, and acts evidence. But you fear he's less believable then.
Right, and I'm looking to bolster his credibility. That's exactly it. Of course,
And you have
the issue.
and you have some. What was the word you used? The adjective.
Dazzling.
Dazzling. Case law to support.
Well, and it was, of course, a word that was based on your reaction to my State v. Weed submission first thing this morning. So I'm still suffering the wounds from that experience and asking the court to let me repeat it in the morning.
So, Judge, if I could, even if we get to that far, he can't bolster. I mean, even if those cases exist and it's more sweeping than maybe we recall or whatever, you can't bolster until it's been attacked of a witness.
That is the general rule.
Yes. So clearly,
maybe that's by the case.
It's his witness right now.
Please let go of the microphone.
I will be shocked if the defense concedes that Mr. Washington is truthful and is telling no lies, and so I am anticipating, I think with good reason, that Mr. Washington will be challenged aggressively and his honesty will be placed into question. I don't think I misread any signs here, and I think the court can, in anticipating the evidence, understand that. Just as we would anticipate anyone in this circumstance, Mr. Washington's circumstance, would be attacked when he reports that the defendant has admitted a crime.
I don't, I don't. I don't buy into your basic precept, which is the fact that these two jailmates, with nothing better to do than to talk about their past exploits, are bragging about their
Rich,
drug crimes.
Just know we're thinking of you today. I realize
and
today's
that
a hard
somehow
day for you.
makes them more believable. This is supposed to be evidence which is supportive of the state's case without painting the defendant as a bad actor.
There's a lawsuit.
And it appears to me it would have the purpose, even though I agree it's less serious than it was once viewed. It accomplishes the purpose of painting the defendant as a bad actor. It also
this would make him younger than me.
No, it doesn't either. But but at the same time, it's what is offered as the support, as the bolstering, is someone bragging about his criminal acts. Now, that's actually not why you're offering. You're offering it to they're relaxing their safeguards, and but boy, the rule was created for a reason, and we can stop now. It's okay with me.
Well,
and you can bring in cases in the morning, and of course, I'm.
From a variety of sources, I am receiving cases, so I feel confident I'll be able to bring something to the court. I have a number of persons who are interested in being of assistance on this issue. So I'm asking the court to break now before the court makes a ruling on this. And obviously we're not going to finish this witness today anyway. The court was going to finish at 4:30. I'm asking the court to let us break now, and we'll revisit this with whatever we can find.
Nicole, you're right.
For whatever it's worth, I'd like to continue.
Well,
with a granting our objection and prohibiting them from going forward with this theory.
I want to do it right, and I want to do it right, and this is why I do my thinking out loud and have these discussions, because people get my mind changed. I think I've changed my mind already in this case once or twice.
Witness gets 2 days out.
So maybe he will dazzle me with some case, or maybe you'll bring some blockbuster here. I don't know, but it's
This
pretty
means we're
clear
having
what
the
my
same debate tomorrow morning.
present
That's what
feeling
this
is.
means.
We can wait till tomorrow.
Judge, the defense would request, similar to how when the state objected during my opening statement and wanted to brief the issue, we had till 9 p.m. to provide something to the other party. I'd ask that if the state's going to be presenting anything to this court in the morning on this issue, that similar courtesy be extended and that they provide that information to the defense by 9 p.m. this evening.
That's like,
what do you think about
that's a time limit.
Well, I'm not able to comply with that because I teach at Parkside tonight, and so I have obligations from 5:40 to 8:45 tonight. But I do volunteer to place. I'll suggest any cases briefly as soon as I can this evening, and then or first thing in the morning if I need to do that. That's my request.
These guys, they hate each other.
Judge, they have a whole office. There's another prosecutor sitting right next to them. I think they can get that done, especially since it's their burden and they're the ones that are wanting to,
but we're
brief this
talking
and
now
interrupt
about,
it.
While I do understand that you, like everybody else, like to sleep, I happen to be going to a meeting, and where I won't have to be dealing with this. I think there's only one other lawyer in the group, so I'll get some relief. And I'll be in that meeting until about 8. So, and I wouldn't reach anything that got submitted until 10 at the earliest. So let's make it 10:30. And
so they have a 10:30 p.m. deadline.
I go to bed early.
Read it in the morning.
They're trying to limit the time the DA has to find.
Judge, we just want to be, sorry, Attorney Mueller speaking. We just want to be prepared. They've said that this case exists. We surely are capable attorneys that can do our own legal research on the issue. But if they're going to be presenting a very specific, nuanced issue, and we don't get that case law until very late hours after we've all gone to bed or early morning, we want to be able to make sure that we have a legitimate argument based in authority to this court.
And the bottom line is that
well, Ivan, can you hear me?
I'm
Ivan's trying to call in.
First off, when
Give us a minute. We want to wrap
graduated
this
and
up
came
first.
into trying cases, we were still working on the ambush system. And frankly, I thought it was more fun than now. But I understand it had many shortcomings. The fact that the fact that something comes in at 10 at night, give you some time. It's not like we're exploring some expansive area of the law. We're in a very, very There's a lot of cases on it. There are more cases on this than anything else.
Hang
there
on,
always
Evan.
are. And the prosecutors have been pushing this further and further away from the original rule for a long, long time. So there's a lot of law on it, but this is a first for me, and yeah, that's a really good idea. Ask them to come in. Are they just in the back room?
Yes.
And then could Mr. Washington then leave as soon as
They're
they
standing in the library.
allowed to leave? Mr.
Indeed.
Washington's on the stand.
In fact, he can leave.
Could he leave now?
Well, I don't want him to bump into them.
Which way are
What?
you taking him? This way or that way?
Bring the jurors in through here. Have him exit through there. You're done for the day, sir. Thank you.
Can you?
I'll see you in the morning.
So there's a keep separate so that you know. And can you have him brought at 9 o'clock tomorrow? Sure. Thanks.
I'm actually going to invite the jurors back at 9:30 because we're going to be working tomorrow for. We'll be let out in a half an hour. All right.
Cameraman's falling asleep on the knob and panning up. Cameron's just a fan of the woodwork. And let's see how long the cameraman goes before he notices he's on the wrong.
Oh, I never get finished. I didn't finish that.
Yeah, we know you didn't finish. Got a lot more to talk about. Ivan, I know I can't take the call until we've got a break here, so I'm just waiting for the judge to excuse the jury. Nope, we're still panning up. I've got an image called The Justice of God.
You're such a nice jury. You really are, and that's sincere. This is what's happening in this particular case is I've been here 40 years, and I've never had one like this. And I'm not blaming anybody. It's the way it is, and you people have been wonderful about it. I can tell you stories. So thank you for that. And we're
hang on, I can't hear you.
Moving ahead, and I'm going to actually ask you to come in at 9:30 tomorrow morning because I know we're going to be going for a while here this afternoon, and we're going to not have it resolved. This particular subject we're talking about.
Can you hear me now, Ivan?
I talked about hearsay and how much of the book it occupied. This particular area of the law we're talking about now is the most litigated area in the law. If you look at the appeals over the years in the various courts, this is far and away the most litigated. So there's a lot of legal work that is involved in this. So give us an extra half an hour tomorrow morning. I recommend an extra half an hour of sleep, but whatever's practical. And I know
hold tight, Ivan. I can hear you. Hang on.
Using your time, but
yep.
we're getting there. Please report at 10:30, 9:30. Forgive me, 9:30. There were 11:30. There we go. Yeah, 9:30, and I'm going to make every effort to get you down here right away and get back onto this. Please don't read, watch, or listen to any account of the trial. Discuss the case with anyone, even members of your household or other jurors. Any questions, anybody? Okay, thank you very much.
Okay. So as they're leaving here, let me just preface here. We do have Ivan on the phone. For some reason, it's only coming in mono instead of stereo, but we'll get that sorted.
Can you hear me?
Yeah, I can hear you. Hang on a second, Ivan. We're just waiting for the court to be done for sure. This is Ivan Victor, who's on the phone right now, and just as by way of introduction, he's a good friend of the program. Ivan's been very open with his personal experience in the past, which involves some time in a federal prison. And so he's got some perspective on this. I just want to wait for the judge to be done before we...
where did I leave it at? By what time tonight? 10? 10 o'clock?
10 o'clock.
You did at one point say 10:30, but we might have changed it. I don't know.
You know me. That's.
I think you changed it to 9.
You changed it to 9.
I misheard. I don't know.
All right.
I'm too busy having games called to me. I missed what time.
I will. I'll make a Solomon-esque decision and say 9:15.
Okay.
9:50. You said 10 before.
Oh, I did.
That was what you just said.
This is funny.
9. All right. 10 o'clock. 10 o'clock.
Judge, can you confirm for us that we are closing testimony tomorrow at 2:30 p.m.? Is that what you said earlier?
We are. We're stopping at what I don't know. I don't know about
Sounds
the
like an
testimony
early day
will be.
tomorrow.
But we are going to stop tomorrow at 2:30. Did I say?
I don't know. You said you had to leave for an appointment at 2:30.
2:30. Okay. 2:30, and I apologize. This was not
It's taken forever.
until a couple days ago.
Just tell everyone to leave and come back in the morning.
He cannot be short-winded.
And then I can come back at 4 and pick up.
Oh, really?
I'm not
I wasn't expecting
encouraging
that.
that because there is a judge's meeting with some issues that I would like to be there for. Although I'm sure Judge Gabrielle would do a wonderful job, even if I'm not there. Maybe. But
eating this up.
But we can go at 4 o'clock if we have to.
Is it an appointment where it's possible that there be a wait as well without telling us the details? So is it possible that you might not make it back?
I would not expect a lengthy wait.
Okay, so judge has an appointment.
My only concern is obviously this jury has gone in, out, waited, in, out.
Yep.
That for them to then wait around for an hour and a half,
Let's just call it
come
an early
back
day
to
tomorrow.
then leave again.
Yeah, that's a good point.
I just want to agree with the defense on something, so I'm going to join it.
Thanks, Mike.
Fair enough. So we will.
I disagree.
We'll wrap it. We'll wrap it up at 2:30.
Okay, so a short day tomorrow. That's good to know. Okay.
Remember the good old days of the stipulation? You remember those days?
Oh, yeah.
That was a while ago.
I don't know why we're still on the record. Is this all being recorded by the court clerk?
That's what I want to know. Like,
Okay, I think we're done. Okay, I'm either way, I'm gonna go ahead and mute the judge. I don't think we're gonna hear anything else. So on the phone, I mentioned we've got Ivan Victor. He's been very open with his past, and he has experience being inside a federal prison for a couple years, serving some time. And so obviously when we had the witness come on today that started sharing information about his time he spent with the defendant as a cellmate, Ivan had some opinions. So I've asked Ivan to breathe deeply, to keep this sort of family friendly, but at the same time, Ivan, when you saw the next witness in shackles and in orange, what went through your mind?
well, my first glimpse upon such a witness is, oh God, here we go again. What's on the table? You know what I mean? Like the fact that he is still in his hunting outfit tells me everything I need to know. Okay, like this is not being done out of the graces of his heart. This is not being done out of the graces of his soul. This is being done out of a deal. Okay, first and foremost, and I cannot.
Ivan, hold off. It just disappeared for me. Are you still there? Can you hear me, Ivan?
I can hear you.
Okay. All right, you're back. Sorry, I should not touch the phone while you're talking.
Okay.
Okay, keep going.
Okay. All I can say is when I see a position, or when I see a person in that position, it just spikes up my spine, because let me tell you, this is not being done out of the graces of his heart. This is not being done because he's a good citizen. It's not. You cannot trust this more than you can trust a $3 bill on the blackjack table. Like I promise you, like it is fraudulent in every sense of the word. And I can't even believe, like, why didn't they get this man a suit? Why didn't they get this man a polo shirt? Are you kidding me?
Yeah. So So at the very beginning of the testimony for this, his cellmate, who's what he is, we basically found out that he's facing federal charges for, I would say, a substantial amount of drugs, about 30 kilos of cocaine and 600 pounds of marijuana. He disputes the amounts, but he's basically says, I haven't pled guilty yet. Right?
He is going away. Like let me tell you, R.A. He is going away for the rest of his natural life. He will say the Easter Bunny did it with Rudolph driving the getaway vehicle. Okay.
So that's the thing that where we're at is he's with these federal charges. The only way you can go get an easier sentence in this situation, because he says, I agree to plead guilty. In return, I'll cooperate, and you get something, I get something. Is if he basically turns somebody in. If he has dirt on somebody, if he does a favor for the feds type thing, get them something they otherwise would not have, and in return for an unspecified amount of leniency on his sentence. Clearly he has huge incentive to make up something fantastic that the feds will enjoy.
All right, it's not just a huge incentive, it is the only incentive. Why now? Why didn't this come out 2 years ago? 3 years ago at the original, you know what I mean? Why didn't this come out originally? Why wasn't he first witness on the scene when he knew it was happening? Because guess what? It didn't benefit him.
Yeah.
You know what I mean? Like,
it's
this guy.
But this
guy is reliable as somebody stating they have a $3 bill at the blackjack table. He is nothing. He is a. I mean, come on.
Okay, but will the jury be able to see that? I mean, it's already been brought up. They've already said basically you have all the reason to lie. Basically, that we've covered that. You have a huge benefit for testifying. Can't the jury look at that and say, yeah, I just can't believe him? Isn't that okay? Can't we just move forward with that?
But my whole point is like that. I would have to believe. Like, I have to have faith in my fellow mankind. And you can't tell me whether you're an old grandmother who is retired, or you're a small business owner, or you're a teacher, or you're a cop, or you're this, or you're that on the jury. Everybody has to see through this scam. You know what I mean? Like, let's give some kind of credence to the human condition for one moment. That's all I have to say.
And you shared in chat already that basically you had a similar opportunity where you were facing federal charges and had opportunity to basically provide information against someone else for your own benefit. You chose not to do that. You just did your full sentence.
Well, I was originally I could have cut my 48-month sentence down to 18 months. But in doing so, guess what I would have had to done, R.A.? I would have had to look over my back for the rest of my life, every single day, okay? Yep. And not just me, but every person I cared about, every person I loved, every person I endeared, every person I gave a SHIT about, okay? Mm-hmm. It wasn't about me at that point. That was my moment. That was my moment of reconciling. It wasn't even just like getting clean or anything like that. That was my moment. Whether I was going to be in a position of turning state's evidence or not. Because guess what? It would have been very easy for me to do that.
Yeah.
But from that very point, everybody I ever gave a shit about would have been at risk for the rest of their life.
So that's a concern Debbie brought up in chat. She says, where are they going to put this witness for his own safety tonight? Is that a concern, like, right now for him?
Well, and let me tell you, yes, there is a statistic out there that will tell you that everybody who joins the witness protection program has 100% success or safety rating. But guess what the caveat to that is? They have to agree to never talk to anybody they ever talk to ever again. Yep. Guess how many people do that?
They don't. They can't. They're like, well, what about my family? What about my friends? What about my connections? My business? I have to say bye to people. Yep.
All it takes is one phone call, RA.
Yeah.
All it takes is one. And once you make that one phone call, you lose all the protections of the federal government. You lose everything. You are kicked out. It is the end. Okay?
I think as far as the information this witness is going to provide, we expect him to say that, obviously the state wants this marijuana information brought in. But it sounds like that may not be allowed, and that's fine. But they're going to go on and ask him questions about what Zachariah told him or talked about. And one of them, I think the information is mostly going to be along the lines of tracking devices, how to track people and how you can track their vehicles and hear what's going on and spy on people. I think that's what we're getting at with this witness. I hope it's worth it for the man who's cut the deal here. But I have to admit, I've been on the other side of this. I've turned people in who did federal time. Now I wasn't an inmate, but I was actually one. Had their plan worked, I would be dead. Right. But there was a scientific, I guess a physics problem in the way that separated their plan and my death. And so instead, I survived and lived, and ended up turning them in. So I can see both sides. There's a side in chat that says, "Hey, they're breaking the law." Yeah. It's not. Stitches get stitches on one side, and then
this is what I know already. Like, I could have cut my time down to federal parole and probation, and maybe a few months in the county jail. Otherwise, I had to do 3+ years with the time that I did.
Yeah,
I could not. At that point, I looked my dad in the eye, and my dad had never come to visit me one time when I was in county jail. Like, you're talking about a Soviet despot who left the Soviet Union. You know what I mean? He has no interest in coming into jails or this or that. Like, you know what I mean? That whatever, you get it. But he came and saw me, and he said, "This isn't about you." You know what I mean? Like, It wasn't about me at that point. Like, when I decided to take my time and eat it, all I'm going to say is that I knew the risk of the game I was playing when I started to play it. Okay? Like, anybody who pretends otherwise is just, that's why they call them rats, because that's what they are. It is the pure sense of the word. Like they know what they're doing. Okay? It is not a mystery. It is not a fantasy. It is not a hidden revolution. They know.
Yeah. Well, Ivan, thank you very much for calling in. I appreciate your insight onto this. I know you were hopping up and down. You wanted to talk right in the middle of it. I think you called me like 6 times in the last 10 minutes trying to get through. That was my problem.
I can't believe this guy. I can't believe this guy in his orange jumpsuit just willingly putting his name out there, like acting as if, like, I fear for him. I fear for his family.
Yeah. That's a concern.
100%. Like, he does not know the implications of what he's doing right now. Like, maybe he does, maybe he doesn't. And if he does, shame on him twice. But my God, this is not a game. You don't get a do-over. This is not a Nintendo, experience. Like, holy smokes. Thank you, R.A. Yeah. I appreciate you 100%. I love you. I love you, Dad.
Thank you. I appreciate you in chat. I appreciate you agreeing to my family-friendly stipulation for this call. So you did a great job there. Thank you very much. We'll be talking to you soon, I'm sure. So have a great night. We'll see you later.
Have a great night, sir.
Bye. All right. I apologize for that audio only coming in one channel. I'll get that fixed. But appreciate that. Appreciate Ivan coming in and sharing that. This is where we're going to wrap it up for the day as far as the trial's concerned. So unfortunately, tomorrow morning, the attorneys, the judge isn't going to come in and just say, "Here's what I've decided." Both the attorneys are going to be like, wait, we've got one more thing, and it will be back and forth. So we're basically going to relitigate or re-argue this objection on both sides to it. And they're both going to have case law one way or the other, back and forth. Then the judge is going to rule. It's probably going to be about a half-hour discussion tomorrow. So we're going to start at 9 o'clock. The jury is not even going to get there till 9:30. The judge knows this is going to take some time. We are adjourned, PFOG. They have let the jury go for the day. Tomorrow, in addition, is going to be a short day. It looks like about 3:30 my time, which is 3:30 Eastern. The judge has an appointment, and they decided just to call it quits for the day. So we're going to get an early out on Thursday and then full day on Friday. I wish they had rethought that and swapped those around. But that'll allow me to get some work done in the garage on the rebuilding project. Anyway, it's been a fantastic day. I love this. I realize there are parts of this that are so boring, and unfortunately, there are parts of true crime that just you want to prop your eyes open with toothpicks just to stay awake type thing. Those happen, but at a moment's notice, you can get an objection that comes in, and it just turns into a firestorm. And that's what I love about this trial. This trial has all of that, has all the battles, the back and forth, the mystery, the intrigue, the missing body. We've got a missing body. And now we've got a jailhouse snitch. We've got all the pieces coming together to just make an incredible trial. I think you guys are going to love this. I think if you stick with this, it's going to get better and better. But honestly, my gut feel, I'm not sure if this will ever get to the jury. We've come so close to the mistrial, and it's happened before. We've come so close to that line. I'm just not sure we can avoid that. So this might all go down in flames long before the judge had calendared this thing to come to a conclusion. But yeah, it's gonna be a blast. Let's see. We're not doing the 9 or 10 p.m. thing. Debbie, here's what I'm thinking. Tomorrow, once this trial is over, I want to go back and cover something that happened just the other day, and it's the Crumbleys case, the parents of Ethan, the shooter. We've got an appellate court hearing on that is spicy as I'll get out as well. Appellate court's different. It's just a different beast. We have the video from that. I'd like to cover that. It's about an hour long. So if we end the trial early tomorrow, we can go back and see what happened there. This is the case where the parents, they're looking at charging the parents for something the son did. And this, it's new ground. The Supreme Court's weighed in and kicked it back to the appellate court. So the appellate court's hearing it. You've got 3 judges sitting there, rapid fire questions at lawyers. And it starts off from the get-go. It starts off spicy. So I think we're going to share that tomorrow. So bring your questions about that as we watch that, but we'll do that after the break. So in the normal time in the afternoon, we'll end still a little bit early, but that'll be good. If anybody has any questions today, thank you very much, PFog. Appreciate the super sticker here.
Fog just sent a super sticker with 2.99.
Love it. The fist bump super sticker. Thanks to all those who subscribed today, who found us from one way or another. I'm glad you made it here. I hope I've earned at least you clicking the subscribe button. I'd love to have you come back and enjoy the rest of this trial with us and with this community. It is a great community. We have a lot of fun here. Occasionally we have some disagreements, but we're still friends. At the end of the day, we're still gonna give each other a hug and have each other's back in a fight. That's how it goes. But thank you very much for being here. Appreciate all of you guys. This is what I feel is the best place on the internet to watch true crime, and that's all because of you. It would not be the same without you. I appreciate it. This channel's grown a ton since we started with Daryl Brooks just a few short months ago, and it has been exciting. It's my dream job, is what it really is. I feel incredibly blessed to be able to come to work every day and get to watch true crime shows with you, to watch trials with you. So it's amazing. Thank you very much. The parents have been in jail for a year. They have. And there's some things there. I mean, we can talk about the Crumbleys and what they did, the fact they were on the run, and you mentioned burner phones and cash and everything else. It's interesting twists. Matthew Harris, one of our resident lawyers here, I think he's actually the first lawyer we had on the channel, is a good friend of the program. He has his own legal channel. He does come on occasionally and provide legal analysis for us when we need that. He's got his own channel here. You can click that link in the chat window and watch his channel. I do highly suggest it. He drops new videos every week, and a lot of them are very entertaining. He's a great guy. It sounds like Nicole from Goodman Law Firm in California is also working on a YouTube channel, which I'm excited about. So I can't wait to have a link to share that, Nicole. I know a lot of people in chat would love to follow you there and get you a jump start on that YouTube channel. So it's awesome. Laura, thanks for finding us. I appreciate it. Thank you very much. Thanks to all those who subscribed. Thank you for all the super stickers and for the super chats. You guys are amazing. The support means everything to me, from Mrs. R.A. and myself. Thank you. Thank you. Thank you. That's it for today, I think. Let me find my music. Hang on. Wait for it. Okay. There we go. All right. Thank you, Debbie. Kind words all around. Tonight when you go home, please hug the people you love. Smile at somebody, make their day just a little bit better. And please stay safe till tomorrow. We're going to go live at 9 a.m. tomorrow doing the same thing, the same channel. We get to finish this argument with the judge. We'll see how he rules. I think this one, the defense is going to win. I think they're not going to get to bring in all the marijuana. You know, we bonded over marijuana talk on this one, but we are going to have the same witness on the stand. We're going to continue just where we left off. So thank you very much, everybody. Please stay safe. 9 o'clock tomorrow morning. We'll see you here. We're going to re-gift the internet too. We give away the internet to every single time we go live to the first person in chat. So if you want that to be you, go ahead and click the notification bell. And when you see that notification, click the first person who says anything in chat, even if it's just the space character or a period or something else. Whatever you say, the first person in chat wins the internet for the day. It's a heavy burden, taking care of everything IP related for everybody, but I'm sure you're up to it. Thanks a lot, everybody. It's been fun. Have a great night. We'll see you in the morning.